Hey guys, tonight we are traveling back to a version of the past that feels, well, a little broken. Imagine a world where the law is so serious, so absolute, that it doesn't stop at humanity's edge. It spills over into the barnyard, the fields, and even into the cracks in the walls. Tonight, you're not just a time traveler, you're a citizen in a world where a pig can be arrested for murder, where a swarm of locusts can be served a court summons, and where a rooster might just face the death penalty for, well, we'll get to that. Honestly, if you were dropped into this era, your biggest worry wouldn't just be the plague or a random lord having a bad day. It might be getting implicated as an accomplice to a thieving donkey. So, before you get comfortable, take a moment to like the video and subscribe, but only if you genuinely enjoy what I do here. Let me know in the comments where you're listening from and what time it is. I love seeing how far these stories travel. Now dim the lights, maybe turn on a fan for that soft background hum, and let's ease into tonight's journey together. The air is thick with the smell of wood smoke, damp earth, and something vaguely like boiled cabbage. You're standing on a muddy, rutted lane in what feels like a small town somewhere in medieval France or Switzerland. Let's say it's the 14th century. Timber-framed houses lean against each other like tired old friends, their upper floors jutting out over the street, casting everything below in a permanent state of twilight. A church bell tolls somewhere in the distance, a slow, heavy clang that seems to measure out the day. This is your new reality, and the first thing you need to understand is that the line between the human world and the animal world is incredibly blurry here. It's not that people think animals are their equals, not at all. It's that they believe everything, and I mean everything, operates under a single, all-encompassing divine law. In your modern mind, law is a human construct for human society. Here, it's different. In the world we've just stepped into, God's law is like gravity. It applies to everything that exists within his creation. Kings, peasants, priests, rocks, trees, and yes, animals. Everything has a place, a purpose, and a set of rules it's supposed to follow. So when an animal does something that violently disrupts this order, like, say, a pig attacking a child, it's not just a tragic accident. It's a crime. It's a tear in the sacred fabric of the universe. And that tear must be mended through the most solemn process they know, the law. You hear a commotion down the lane. It's not a celebration, not a festival. The sound is more formal, more tense. You see a small crowd gathering, their faces a mixture of morbid curiosity and grim satisfaction. Pushing your way through the damp wool and linen-clad bodies, you see the source of the fuss. There's a man, a local bailiff, his face set in a mask of stern importance, and in front of him, looking utterly bewildered, is a large, mud-caked pig. This is where you encounter a crucial, and frankly bizarre, bit of medieval legal theory. They made a clear distinction between two types of animal defendants. First, you have the individual animals, pigs, cows, horses, dogs, especially those living in close contact with people. These animals were seen as having a kind of semi-responsibility and worked right in secular or criminal courts. Just like a person would be, they could be arrested, imprisoned, and executed. Then you had the pests, rats, locusts, weevils, caterpillars, creatures that committed their crimes as a collective horde. You can't exactly hang a million locusts. These cases were handled by the church courts, and the punishments were, shall we say, more spiritual in nature. What you're witnessing right now is the first kind, a domestic animal, accused of a capital crime. Someone in the crowd mutters that the pig wandered out of its pen in mold, an infant left unattended in a cradle. A terrible tragedy. But the reaction isn't just grief, it's a demand for justice, for legal process. And this is where historians still get into some pretty heated arguments at their conferences, probably over lukewarm coffee and stale croissants. Were these trials a result of a genuine, literal belief that a pig could possess mens rea, a guilty mind, The same kind of malicious intent a human murderer would have, or were they a form of community therapy, a ritualized way for a village to process a horrific event, assign blame, and restore a sense of cosmic order in a world that felt chaotic and terrifying by putting the animal on trial. They weren't just punishing a beast, they were performing a public act that declared, "We see it as evil, we are judging it, and we are casting it out. Order is restored." The actual belief system of the average peasant or judge is, for us, lost to time, and scholars still debate whether this was legalism spun out of control or a deeply felt spiritual necessity. You watch as the bailiff, with all the gravity of a man arresting a treasonous duke, ties a rough rope around the pig's neck. The pig, of course, just lets out a confused oink, its little eyes blinking in the gloom. It is completely, blissfully unaware that it has just been formally charged with murder. It is now a defendant in the eyes of God and man. And in this world, that's a very dangerous thing to be, especially if you're a pig. The pig stands there, utterly unconcerned, its snout twitching as it sniffs at a loose cobblestone. For you, it's a farm animal. For everyone around you, it's now a felon. And as you'll quickly learn, in the grand hierarchy of animal criminals in the Middle Ages, pigs were the undisputed kings. They were the serial offenders, the usual suspects. If you look through the surviving court records from this period, which are admittedly spotty, you'll find that pigs are implicated in more capital cases, specifically the killing of children, than any other animal, by a long shot. And when you think about it, it kind of makes a grim, practical sense. This isn't the era of neatly packaged bacon from a supermarket. This is a time when pigs were everywhere. They weren't just kept in tidy farm pens, miles from town. They were walking, snorting, omnivorous part of urban and village life. Many families, even in towns, would own a pig. It was a living garbage disposal and a future source of precious meat and fat. But they were often allowed to roam freely through the streets during the day, a practice known as commoning. So you did have these large, powerful animals, weighing hundreds of pounds, snuffling their way through the same muddy lanes where children played. You follow the small, grim procession as the bailiff leads the pig away. The animal isn't exactly cooperating, occasionally planting its feet and forcing the man to yank hard on the rope. It seems less like an arrest and more like a stubborn farmer trying to get his price out to market. But the atmosphere is completely different. The faces of your new neighbors are stone cold serious. They're witnessing justice in motion. A child is dead, and the cause of that death must be dealt with according to the letter of the law. To them, ignoring the pig's crime would be like ignoring a human murderer. It would be an insult to God and a danger to the community. This brings us to a rather fascinating, and slightly disgusting, little detail about medieval life: the concept of the ravening pig. The fear of pigs, particularly their potential to harm infants, was a very real and present anxiety. Infants were often left swaddled and unattended for periods of time, sometimes in low-lying cradles, while their parents worked in the fields or the home. A roaming, hungry pig, drawn by the smell of milk or food, could, and sometimes did, inflict horrific injuries. The records are full of terse, heartbreaking accounts. A pig did fatally wound the child of Jean Laurent. One might read, the pig did devour the face and arm of the infant. In a world without modern medicine, any serious injury was a potential death sentence, and the pig's powerful jaws could be devastating. So while it seems absurd to us, the trial of a pig was rooted in a genuine, everyday terror. The procession stops in front of a squat stone building with a heavy wooden door. This, you realize with a jolt, is the local jail, the very same place they do lock up a human thief, a brawling drunk, or a suspected murderer. And now, it's about to have a new, four-legged inmate. You watch as the jailer, a large man with a key the size of a small loaf of bread, unlocks the door. There's a bit of a struggle, a lot of squealing and grunting, but eventually, they manage to shove the pig into a dock. straw-strewn cell, the heavy door booms shut. The pig is now officially incarcerated, awaiting trial. And this wasn't just for show. The records show that accused animals were kept in the local jail at the public's expense. The town or the local lord had to pay for the animal's food and lodging while it awaited its day in court. You can even find old account books that detail these expenses for the sow in prison. 6 deniers. Item. For bread and water for the pig. 1 SOU. It seems almost comical, but it underscores the seriousness of the procedure. The pig wasn't just being held, it was being treated as a legal entity, a prisoner with, in a strange way, rights. It had the right to be fed, the right to be held until trial, and, as you will soon see, even the right to a legal defense. Historians have long debated the nuance of this. Was this practice uniform across Europe? The answer is a clear no. The overwhelming majority of documented cases come from a very specific geographic area, France. The Holy Roman Empire, especially the German-speaking parts, Switzerland, and parts of Italy, for some reason. This legal quirk didn't really catch on in England. The English law had its own way of dealing with killer animals, a concept called deodient, where the object or animal responsible for a death was forfeited to the crown or the church, to be sold for charity. The animal was an instrument of death, a thing to be given to God, but it wasn't a criminal. Why this sharp legal divergence exists is a question that still keeps legal historians typing away in dusty university archives. It suggests that the animal trials weren't a universal medieval belief, but a very specific, regional interpretation of law, God, and the nature of justice. Standing there in the fading light, listening to the occasional, muffled doink from behind the jailhouse door, you're left to ponder this. The pig in that cell has no idea what is happening. It just knows it's in a dark room instead of its usual sty. But for the people of this town, a great and terrible wrong is beginning to be set right. A monster has been caged. The air grows colder as night settles over the town. The sliver of a moon does little to pierce the oppressive darkness between the houses. From the tavern down the lane, you can hear a burst of rowdies singing. But here, near the jail, the mood is still heavy. The pig is locked away. But its fate is far from sealed. Its entire future, and indeed its life, now depends on which court will hear its case. And in this world, that is the most important question of all. You have to wrap your head around the fact that medieval society operated under a complex, overlapping, and often competing legal system. It wasn't one neat pyramid of justice. It was more like two separate pyramids, built right next to each other, occasionally leaning over and knocking bricks off one another. On one side, you have the secular courts. These are the courts of kings, dukes, and local lords. They deal with crimes of the flesh and blood: murder, theft, assault. This is the system that governs people. And as you've just seen, it's also the system that handles the crimes of individual animals like our friend, the pig. The punishments here are physical and final imprisonment, branding, hanging, or burning at the stake. On the other side, you have the ecclesiastical courts, the courts of the church. These are run by bishops and other high-ranking clergy. Their jurisdiction is over matters of the soul and of divine law: heresy, blasphemy, moral failings, and disputes over church property. And, most importantly for our story, they claim jurisdiction over those collective pests, the creatures that swarmed and devoured but couldn't be individually arrested: the locusts, the rats, the caterpillars, the weevils. These were seen not as common criminals, but as a divine scourge, a punishment from God for the sins of mankind. Therefore, only God's representatives on earth, the church, could properly deal with them. The punishments they handed out weren't physical, because you can't hang a million weevils. Their weapons were spiritual: formal warnings, curses, and the ultimate bomb in their arsenal: excommunication. So you have two distinct paths of justice. For the pig in its cell, the road leads to a secular courthouse. a human judge, and likely a hangman, for a field of crop-destroying beetles. The road leads to a bishop's court, a theological debate, and a priest wielding a holy relic. This dual-track system is one of the defining features of the era, and it created all sorts of legal headaches and power struggles. It's also where some of the most surreal moments in legal history take place. Let's think about the pig for a moment. Its crime was singular and physical. It killed one specific victim at one specific time. It can be identified, captured, and held accountable. The logic, twisted as it may seem to us, is internally consistent. The trial will be about establishing the facts of this specific case. Did this pig commit this act? The process will mirror a human trial, with witnesses, evidence, and a verdict aimed at that single defendant. The outcome is binary: guilty or not guilty, life or death. Now, picture the alternative. Imagine you're a farmer, and your entire vineyard, your livelihood for the year, is being systematically destroyed by a species of small, green beetles. What do? You can't catch them all. So you and your fellow villagers go to the local bishop. You file a formal complaint. The ecclesiastical court then takes up the case. Their first step isn't an arrest, but a theological investigation. They might send out a commission to survey the damage and determine if the plague of beetles is indeed unnatural or excessive. They have to be sure it's not just, normal beetle behavior. This is a strange but important little detail. The church had to be careful. They believed that God sometimes sent plagues of insects as a legitimate punishment for a village's sins. If that were the case, interfering would be going against God's will. The court first had to determine if the people were at fault. They might order the villagers to pray more, to repent, to participate in special processions, or to pay their tithes more promptly. It was a form of spiritual housekeeping. Only after the human side of the equation was deemed clean could they turn their attention to the beetles themselves. This is a key difference. The secular court asks, is the animal guilty? The church court asks, are we guilty? And is this swarm of animals the instrument of our punishment? The purpose of the two courts reveals their fundamental difference in worldview. The secular court's goal is punishment and the restoration of social order. It's about retribution. The ecclesiastical court's goal is reconciliation and the restoration of divine order. It's about persuasion and spiritual coercion. They sought to persuade the pests to leave, using the threat of God's wrath as their leverage. Historians are still untangling the complex web of motivations behind this split. Was it a genuine theological division? A belief that different types of creatures required different legal approaches, or was it a classic medieval power grab by claiming jurisdiction over acts of nature like plagues and infestations? The church reinforced its authority, demonstrating that it held the keys not just to heaven, but to a successful harvest. It was a powerful way to keep the populace pious and the tithe barns full. The line between sincere faith and shrewd institutional maneuvering was, as always, incredibly thin. So as the pig settles in for its first night in jail, its fate is already set on a specific, grim path. It has no hope of being gently cursed and told to go away. Its alleged crime was too personal, too earthly. It has fallen squarely into the world of men's law, and it will be judged by its unforgiving standards. The next morning, a pale, watery sunlight filters into the narrow streets. The town slowly comes to life with the familiar sounds of roosters crowing and the clatter of wooden shutters being thrown open. But there's an official chill in the air. Justice, or at least the medieval version of it, is a slow grinding wheel. And its first turn today is the crime scene investigation. You're about to witness something that feels both surprisingly modern and deeply, profoundly strange. You follow the bailiff, who has now been joined by a couple of other important-looking local men, perhaps aldermen, or junior magistrates, as they make their way to a small, humble cottage on the edge of town. A woman, her face swollen with grief, stands at the doorway, being comforted by neighbors. This is the home of the victim. The men approach the scene with a solemnity that would, to your eyes, be more fitting for the murder of a nobleman than for a tragedy involving a pig. You step over the threshold into a single, dark, earth-floored room that serves as the kitchen, living area, and bedroom. The air inside is heavy with the smell of stale straw and sorrow. In the center of the room is the focal point of the tragedy, a simple wooden cradle, now empty. This is the corpus delicti, the body of the crime. The men gather around it, their voices low and serious. They are here to collect evidence and take witness statements, just as detectives would today. The bailiff begins the inquiry. He questions the mother, who tearfully recounts the events. She had just stepped outside to fetch water from the well, leaving the baby for only a few moments. She heard a terrible squeal, not from the pig, but from her child, and rushed back in to find the neighbor's pig, its snout bloody, standing over the cradle. Her screams drew the rest of the village. It's a gut-wrenching, straightforward story. The men then turn their attention to the physical evidence. One of them kneels down, examining the floor around the cradle. He points to a set of cloven hoof prints clearly visible in the packed dirt of the floor. They note their size and shape. He then inspects the cradle itself. There are scratches and gouges in the wood, and most damningly, the swaddling clothes inside are torn and stained with blood. They carefully collect a piece of the bloody cloth. This is Exhibit A. It's a chillingly familiar process. They are building a case, piece by piece, establishing the facts that will be presented in court. Now here comes one of those wonderfully bizarre historical nuggets. In some of these animal trials, the investigators would go a step further. They would sometimes bring the accused animal back to the scene of the crime. This practice was rooted in an old, deeply held superstition known as the cruntation, or the ordeal of the bear. It was believed that the body of a murder victim would spontaneously begin to bleed again if the murderer came near it. While this was more commonly used in human murder cases, the principle was occasionally applied to animal suspects as well. Can you just imagine it? The grim-faced officials, the grieving family, all gathered around the victim's body, leading a bewildered pig into the room to see if a supernatural sign would confirm its guilt. The historical record on how often this happened with animals is thin, but the fact that it happened at all speaks volumes about their worldview, where the boundaries between the physical and the supernatural were practically non-existent. The officials in your scene today are a bit more pragmatic. They seem content with the physical evidence and the eyewitness testimony. They make careful notes. The bailiff produces a document, an official report of the investigation. He records the date, the location, the victim's name, the owner of the pig, and a summary of the evidence. It's all being formalized, turned into paperwork. This isn't mob justice, it's bureaucracy in action. This report will form the backbone of the prosecution's case. The owner of the pig, a nervous-looking man who has been hovering at the edge of the crowd, is also questioned. He confirms the pig is his. He insists he had secured the pen that morning, that the animal must have broken through a weak spot in the fence. His testimony is also noted, but it's unlikely to help his pig. In the eyes of this legal system, negligence on the owner's part doesn't absolve the pig of its own criminal responsibility. The pig is the one that committed the act, so the pig is the one that must be tried. The debate among historians here is fascinating. Some argue that these investigations show a surprisingly rational, almost scientific, approach to justice. They were gathering empirical evidence, after all. But others point out that this rational process was in service of a fundamentally irrational premise that a pig's actions could be judged by human moral and legal standards. It's like using a highly advanced GPS system to navigate to a city that only exists in a fairy tale. The tools are logical, but the destination is absurd. This clash between procedural rigor and bizarre belief is what makes these trials so endlessly captivating. Were they trying to be fair to the pig, or were they just trying to make their unusual justice system look as legitimate and unassailable as possible? It's a question scholars still puzzle over. As the officials finish their work, satisfied that they have a solid case, they roll up their documents and depart. The scene is now set. The crime has been investigated. The evidence gathered. The suspect is in custody. The wheels of justice have begun to turn, and they are grinding slowly, inexorably, towards a formal trial. The pig in its cell has no idea, but the full weight of the local legal machine is now poised to descend upon it. A couple of days have passed. The initial shock in the village has subsided into a low hum of grim anticipation. Life goes on, but everyone is aware of the prisoner in the local jail, the one with the snout and curly tail. The official report from the crime scene has been filed with the local magistrate, and the decision has been made there is sufficient evidence to proceed with a formal trial. The next step is one that solidifies the pig's bizarre legal standing. It's time for the official arrest and the formal documentation of the prisoner. You find yourself back in front of the squat stone jailhouse. The same bailiff as before is there, but this time HES accompanied by a clerk carrying a ledger and an inkpot. This isn't just about keeping the pig locked up anymore. This is about officially entering it into the judicial system. The jailer swings open the heavy door, and the pig is hauled out, blinking in the daylight, squealing in protest. It probably thinks it's finally being let out, perhaps heading for a nice mud puddle. It is sorely mistaken. The clerk opens his large, leather-bound book. This is the official prison register. He dips his quill in the ink, and, with a series of scratchy strokes, he begins to make an entry. He notes the date of incarceration. He notes the prisoner's name, which is usually just a description: one pig, property of Jean Papon. He then records the charge for the murder of the infant son of Jean Laurent. The pig is now, for all intents and purposes, a line item in the bureaucracy of crime and punishment. It has a rap sheet. This is the moment that truly separates these proceedings from simple vengeance. Mob justice is quick and messy. Legal justice, even this strange version of it, is all about process. It's about paperwork. You can almost picture the clerk, with his serious, focused expression, trying to get the details just right, as if the legitimacy of the entire system depended on the neatness of his handwriting. And in a way, it did. By documenting everything, they were validating their actions, wrapping them in a cloak of officialdom. It transformed the bizarre act into a state's ancient procedure. Now for a wonderfully weird and telling detail about the conditions of these animal prisoners. As I mentioned, the accused pig was fed at the public's expense, but the quality of that food could become a point of legal contention. In one documented case, the jailer was feeding the imprisoned pig such poor quality scraps that the animal began to lose a significant amount of weight. The court officials were concerned not out of any great humanitarian love for the pig, but because they felt its poor physical condition might prejudice its case or make it an unfit subject for execution. An order was actually issued, commanding the jailer to provide better food so the pig would be healthy for its trial and potential punishment. The system demanded a robust defendant, even if that defendant was destined for the gallows. Furthermore, the pig in your scene is being held in the same jail as human prisoners. The records are clear on this. Sometimes they were given a separate cell, but in smaller, more crowded jails, they could be held in close proximity to human inmates. Imagine being locked up for debt or theft, and your new cellmate is a 300-pound sow who is, according to the law, your legal peer in criminality. It's a scenario that's hard to wrap your head around, but it was a reality. This cohabitation of human and animal prisoners further blurred the lines, reinforcing the idea that, before the law, all criminals were simply criminals. This practice of jailing animals, however, raises a question that historians love to debate: was the imprisonment itself part of the punishment for a human? Being deprived of liberty is a core component of the penalty. But does a pig experience the loss of freedom in the same way? Does it comprehend its confinement as a consequence of its actions? Almost certainly not. So were they jailing the pig to punish it? Or were they simply jailing it for the same practical reason they de-jail a human to ensure it couldn't escape and would be present for its trial? Most scholars lean towards the latter. The imprisonment was a logistical necessity of their legal process. They needed the defendant to be physically present in court. The fact that the defendant was a pig was a secondary. albeit very strange, detail. As the clerk finishes his entry, he blows on the ink to dry it. The bailiff gives the rope a tug. The pig is now officially arrested and processed. Its existence as a legal person, or at least a legal entity, is now enshrined in ink and parchment. But the process is not yet complete. The town has provided the pig with room and board, and it has given it a criminal record. Now, in the interest of a fair and balanced trial, the system is about to provide the pig with one more thing: a lawyer. You heard me right. The next man to visit the pig in its cell won't be a jailer or a judge. It will be its court-appointed defense attorney, and his job will be to save his client's bacon. The idea of a lawyer for a pig sounds like the punchline to a very old joke, but in the world you're now inhabiting, it was a dead serious part of the legal process. A few days after the pig's official arrest, a man arrives at the jail. H.E.S. not a farmer or a bailiff. H.E.S. dressed in slightly better clothes, perhaps a dark woolen robe, and he carries a satchel full of papers. He is a lawyer, a man of letters and legal arguments, and he has been appointed by the court, or in some cases, hired by the pig's owner, to a job that seems, to your modern eyes, utterly impossible: defending a pig against a charge of murder. You watch as H.E.S. led to the pig's cell. The jailer unbolts the door, and the lawyer peers inside. His mere client is, predictably, lying in the straw, perhaps giving a lazy grunt. This is the first client conference. The lawyer can't exactly ask the pig for its version of events. He can't ask it about its motivations or if it has an alibi. The usual tools of the legal trade are completely useless. And yet, his duty is clear. He must mount the best possible defense for his client, using every legal argument and procedural loophole he can find. So who were these lawyers? They weren't village idiots. These were often highly educated, respected legal professionals. The most famous animal defending lawyer in history was a man named Bartholomew Chasney, a French jurist in the 16th century. He made his name defending a group of rats that were being prosecuted by the church courts for destroying a barley crop. His brilliant, and ultimately successful, defense of the rats made him famous and launched a stellar legal career. He wasn't some fringe lunatic, he was a top-tier lawyer who took on an animal case. To refuse a court appointment, even for a pig, could have damaged a lawyer's reputation and career. It was a professional obligation. The lawyer in your scene spends a few minutes just observing his client. He then turns his attention to the official documents, the bailiff's report, the witness statements, the charges. This is where he can actually do his job. He isn't defending the pig's actions, he's scrutinizing the legal process. His goal is to find a flaw, a technicality, a way to introduce reasonable doubt, not about what the pig did, but about whether the trial itself is legally sound. This brings up a fascinating cold case from the historical records, a little-known detail that highlights the seriousness of this legal representation. In one case, a lawyer defending an animal argued that the court had not followed proper procedure because his client had not been read its rights at the time of its arrest. While the concept of Miranda rights was centuries away, the principle of proper legal notification existed. The argument was, of course, thrown out, but the fact that a lawyer even thought to make it is astounding. It shows they were using the exact same playbook they would for a human client, adapting the arguments where they could. So what kind of defense can he possibly prepare? His strategy will likely fall into one of three categories. First, procedural arguments. Was the arrest warrant properly issued? Were the witnesses reliable? Was the crime scene investigation conducted according to the rules? He will pore over every piece of paper, looking for a single misplaced comma or a procedural misstep that could get the case thrown out. Second, he might try a change of venue argument. Although this was more common in the church court cases, he could argue that the court in this town is prejudiced against his client, given the local outrage over the infant's death. He might petition for the trial to be moved to a neighboring jurisdiction where, theoretically, the pig might get a thorough hearing. Third, and this is where it gets really creative, he could make arguments based on theology and natural law. He might argue that his client is a creature of God, acting according to the nature God gave it. A pig is, by nature, an omnivore that forages for food. It lacks the higher reason and moral understanding that God gave to man. Therefore, can it truly be held to the same standard of guilt? Can a creature that does not know the difference between right and wrong be punished for doing wrong? This was a thorny theological problem, and a clever lawyer could turn it into a powerful defense. It was, in essence, a medieval insanity plea, arguing that the pig lacked the mental capacity, the mens rea, to commit a crime. The debate over the motivation of these lawyers is still a hot topic among historians. Were they true believers in the system, genuinely fighting for the rights of their animal clients, or were they ambitious professionals who saw these bizarre cases as a golden opportunity to show off their legal brilliance? Imagine the professional kudos you'd get for successfully defending a pig on a murder charge. If you can win that, you can win anything. A lawyer like Bartholomew Chasney became a celebrity by taking on a seemingly unwinnable case for a pack of rats and arguing it with such dazzling skill that he left the prosecutors speechless. It was the ultimate legal flex. It's likely the motivation was a mixture of both a genuine belief in the necessity of a fair legal process for all defendants, combined with a healthy dose of professional ambition. As the lawyer leaves the jail, his face is a mask of concentration. He has his work cut out for him. He must now retreat to his study, consult his law books, and craft a defense for a client that cannot speak, cannot understand, and is, at this very moment, probably just hoping for some more kitchen scraps. The stage is being set for a courtroom drama unlike any other. The day of the trial arrives. There's a palpable buzz in the town, a mixture of solemn occasion and public spectacle. The trial is to be held in the main hall of the local chateau, or perhaps a dedicated courthouse if the town is large enough. It's a space usually reserved for disputes between merchants or the trial of human criminals. Today, the defendant is different. You find a spot on a wooden bench at the back of the crowded hall. The room is cavernous, with high, timber-beamed ceilings and tall, narrow windows that let in slivers of grey light. The air is chilly and smells of damp stone and unwashed bodies. At the front of the room, on a raised platform, sits the judge, HES, a local magistrate, a man of significant standing, possibly a minor nobleman. He wears a fur-trimmed robe and a stern expression. He is the embodiment of the law, and he is taking this all very seriously. Flanking him are clerks, ready to record the proceedings. To one side sits the prosecutor, a man whose face is a mask of grim determination. To the other side sits the defense attorney you saw at the jail, his papers neatly arranged in front of him. Then, the defendant is brought in. Jabalos led the pig into the center of the courtroom. The animal is secured with ropes, and it lets out a confused squeal that echoes oddly in the formal space. The crowd murmurs. The pig, of course, has no idea where it is. It sees a room full of people and probably just feels stressed and cornered. But for everyone else in the room, this is a crucial moment. The accused is present, facing its accusers, before the eyes of the law and God. Its physical presence is essential for the legitimacy of the trial. The judge bangs a gavel, and the room falls silent. The clerk stands and reads the charge in a loud, formal monotone. Let it be known that this court is now in session to hear the case against one pig, property of Jean Pepon, charged with the heinous and willful murder of the infant son of Jean Laurent, in defiance of the laws of God and man. The prosecutor rises to present his case. It's a straightforward and brutal presentation. He calls the grieving mother to the stand. Through tears, she recounts her story again. The prosecutor is gentle but firm, guiding her testimony to establish the key facts. Then, he calls the neighbors who first arrived on the scene. They corroborate her account. He presents the physical evidence, the bloody cloth from the cradle, the detailed drawings of the hoof rips found at the scene. He builds a solid, damning case. Brick by brick, the evidence is, frankly, overwhelming. It's clear the pig did what it's accused of doing. Now it's the defense attorney's turn. This is the moment everyone has been waiting for. How do you cross-examine a witness when your client is a pig? The lawyer stands, and with a calm, respectful demeanor, he begins. He doesn't challenge the mother's grief. Instead, he focuses on the details. You say you were gone for only a few moments. He might ask her gently, could it have been long enough? Perhaps, for another animal, a strayed, or perhaps, to have entered and left before you returned. He is planting the tiniest seeds of doubt. He questions the neighbors about the exact position of the pig when they entered. Was it standing over the cradle, as the mother recalled in her grief, or was it merely in the same room? This brings us to a peculiar, and frankly a bit dark, little piece of historical trivia. In some of these trials, the court would actually call the other animals from the same farm or household as character witnesses. No, they didn't put a cow on the stand and ask for its opinion, but the lawyer for the accused pig might argue, for instance, that his client should be shown leniency because the other piglets from its litter had always been docile and well-behaved. It was an attempt to argue that the violent act was an aberration, an uncharacteristic moment of madness rather than a sign of an inherently evil nature. It's a strange echo of a modern defense attorney bringing in friends and family to testify to a defendant's good character. The judge listens to all of this with unwavering patience. The whole proceeding is conducted with the utmost gravity. There is no snickering, no sense of irony. This is the part that historians still grapple with, the sheer, unblinking seriousness of it all. Was this a form of mass delusion? A society-wide agreement to participate in a solemn farce? Or did their worldview make this entire scene feel completely logical and necessary? The academic consensus tends to lean toward the idea that this was a legal performance. The community needed a way to process a horrific event that defied easy explanation. A child's death at the metaphorical hands of a pig was a rupture in the natural order. The trial was a highly structured, public ritual designed to mend that rupture. By putting the pig through the same legal process as a human, they were elevating the crime to the level of human tragedy, giving the victim's death a gravity and meaning it might not otherwise have. It was less about the pig and more about the people. You look from the stoic judge to the earnest lawyers, to the bewildered pig standing in the middle of the floor, occasionally tugging at its ropes. The whole scene feels like a dream, a play written by a madman. Yet, for everyone here, it's deadly serious. The prosecutor is fighting for justice for a dead child. The defense attorney is fighting for his client's life and his own professional reputation. And the pig is probably just wondering when it will be fed. The fate of this animal, its very existence, now rests on the finely balanced arguments of the men in this room. The prosecutor has made a compelling, evidence-based case. The pig was at the scene. The pig had blood on its snout. The pig is, by all reasonable accounts, responsible for the child's death. Now, all eyes turn to the defense attorney. He can't deny the facts, so he must attack the very foundation of the charge. He must argue law, theology, and philosophy. You lean forward on the hard bench, ready to hear a line of reasoning that simply wouldn't exist in any other context. The lawyer begins his closing argument, his voice calm and measured, filling the cold stone hall. He doesn't start by talking about the pig, he starts by talking about God. Honorable Judge, he begins, we have heard heartbreaking testimony today. A tragedy has befallen our community, and it is right that we seek justice. But justice must be tempered with reason, and our reason must be guided by God's own laws of nature. This is his opening salvo. He's shifting the ground from the specific crime to the general nature of the defendant. He might then bring up the argument of divine creation. God, in his infinite wisdom, the lawyer might continue, created the pig. He gave it a snout with which to root, a stomach that can digest all manner of things, and an instinct to seek sustenance. He did not, however, grant it the light of human reason. He did not give it a soul capable of understanding the 10 Commandments. My client is not a man, and we do it a great disservice to the divinely ordained order of the world to judge it as one. This is the medieval equivalent of the Twinkie defense. but with a theological twist. HES arguing that the pig was just being a pig. It was acting on the instincts God gave it, not out of malice or moral depravity. He is, in essence, arguing for a kind of diminished capacity on behalf of the entire porcini species. Then, he might pivot to a procedural argument, one that is both brilliant and absurd. He could bring up the legal status of his client. The prosecution, he could declare, has treated my client as a person, charging it with a crime that requires intent. Yet, this pig is also legally considered property. It is owned by Jean Papon. So, which is it? Is it a person capable of criminal intent, or is it property? An object without a will of its own. The prosecution cannot have it both ways. If it is property, then the blame lies with the owner for failing to contain it. If it is a person, then it must be afforded all the rights of a person, including the right to be judged by a jury of its peers. This was a real argument. Lawyers would sometimes demand a jury of other pigs, knowing full well it was an impossible request. It was a clever tactic designed to highlight the logical inconsistencies of the trial itself. The goal wasn't actually to get a pig jury into the courthouse, it was to force the judge to confront the legal paradox at the heart of the case. Now for a wonderfully strange and very real defense strategy that was used by the great Bartholomew Chasney in his famous defense of the rats. The church court had issued a summons for the rats to appear and answer for their crimes. The rats, of course, did not show up. The prosecutor demanded a judgment by default, but Chasney stood up and argued that his clients, the rats, had a legitimate reason for their absence. He argued that the summons had been issued to all rats in the region, but that they were a widely dispersed population. For them all to receive the summons and make the journey to the courthouse would be a long and perilous undertaking. Furthermore, he famously argued, the journey is fraught with danger, as my clients must be ever wary of their mortal enemies, the cats, who lie in wait to ambush them. It is a known legal principle that a defendant cannot be compelled to attend court if their life is at risk on the way. The court, amazingly, accepted this argument and ordered the local parishes to warn their cats not to harass the rats on their way to trial. While your pig lawyer isn't dealing with a summons, you might use a similar line of creative reasoning. He could argue that the pig, being a simple creature, was unduly frightened by the commotion of its arrest and therefore could not be expected to comport itself properly in a court of law. He might even argue that the pig's squeals of protest were not a sign of guilt, but a plea for understanding from a creature that cannot speak our tongue. The core of the lawyer's job, and the point that legal historians find so endlessly fascinating, was to use the system's own logic against itself. The system said, animals are subject to our laws. The lawyer replied, okay, if they are subject to our laws, then they are also protected by the full procedural safeguards of those laws, no matter how absurd that application may seem. It was a form of legal jiu-jitsu. The question of whether these lawyers actually believe their own elaborate arguments is, of course, unanswerable. Some probably saw it as a purely intellectual exercise, a game of logic. Others may have had genuine moral or theological reservations about executing an animal. And some, perhaps, were simply doing their job to the best of their ability, fighting for the underdog, or in this case, the underpig, because that's what a good lawyer does. The system demanded a defense, and they provided one, using all the creativity and erudition at their disposal. As the lawyer concludes his speech, the courtroom is silent. He hasn't denied that the pig was responsible for the death. Instead, he has raised a series of troubling questions about justice, nature, and God's law. He has given the judge a way out, a set of legal and theological reasons to choose mercy over retribution. The pig's fate now hangs in the balance, resting entirely on whether the judge will be swayed by the cold facts of the prosecution or the philosophical arguments of the defense. The defense attorney has rested his case. His words, a strange tapestry of legal procedure and theological speculation, hang in the cold air of the hall. The prosecutor has made a final, Brief rebuttal, sticking to the hard, emotional facts of the case: a dead child, a grieving mother. Now, there is nothing left but the judgment. The entire room, the crowd, the lawyers, the bailiffs holds a collective breath. The only creature in the room not gripped by the tension is the defendant itself, which has decided now is a good time to scratch an itch by rubbing against the leg of a table. The judge, who has been listening intently, his face unreadable, now shuffles his papers. He leans forward, his voice low but carrying to every corner of the room. He begins by acknowledging the tragedy and the pain it has caused the community. He commends both the prosecution and the defense for their diligent arguments. He is following the script, demonstrating that this is a considered, deliberate process. He addresses the defense's arguments first. The court has listened with interest to the learned counsel's arguments regarding the nature of the beast. He might say, his tone formal, the argument that the animal lacks reason and acts only on instinct, as created by God, is a powerful one. For a moment, a flicker of hope might pass through the pig's owner, who is watching from the crowd. The judge is acknowledging the philosophical loophole. However, the judge continues, and the mood in the room shifts. The law of this land is clear. It is based on the sacred principle that all of God's creation exists in a divine order. When an act is committed that so violently disrupts this order, that brings death and chaos into our community, it is a crime against that order itself. It is an act of evil, regardless of the mind that conceived it. HES shutting the door on the "it was just being a pig" defense. He is affirming the core belief that underpins the entire trial, that the act itself, the malefic IUM, is what matters. The pig, by killing a human child, a being made in God's own image, has committed the ultimate transgression. It has stepped out of its place in the great chain of being. The evidence presented by the prosecution, the judge intones, his eyes sweeping over the courtroom, is irrefutable. The testimony of the witnesses and the physical evidence from the scene point to one conclusion and one conclusion only. He pauses, letting the weight of the moment settle. This court finds the defendant, the pig, guilty of the crime of murder. The words land with a heavy finality. A quiet gasp ripples through the crowd. It's the verdict they expected, the one they probably wanted. But hearing it said aloud in the solemnity of the court makes it real. The grieving mother weeps, a sound of sorrow mixed with a terrible, grim relief. The defense attorney bows his head slightly, his face showing no emotion. He has done his job. The outcome was beyond his control. The judge isn't finished. Now comes the sentencing. Having been found guilty of this most grievous crime, he says, his voice rising in authority, this court sentences the condemned pig to be taken from this place to the public square and there to be hanged by the neck until it is dead. Hanging, the same death sentence a human murderer would receive. The symmetry is deliberate and powerful. This wasn't just about killing a dangerous animal, it was about performing a parallel execution. A mirror image of human justice. But there's more. The judge might add a specific, symbolic flourish to the sentence, something to emphasize the nature of the crime. This brings us to a rather gruesome, but historically documented, bit of legal practice. In some cases, particularly in France, the animal was sentenced to be dressed up in human clothes for its execution. A male pig might be dressed in a man's waistcoat and breeches, a sow might be fitted with a dress. In the infamous 13i Texas case of the pig of Falaise, the animal, which had killed an infant, was not only hanged but was first mutilated in the head and falls, mirroring the injuries of its victim, and then dressed in a man's jacket before being executed. This wasn't just about punishment, it was about anthropomorphizing the animal at the moment of its death, forcing it into a human form to fully absorb the human penalty it had been given. Historians are still debating the precise meaning of this bizarre ritual. Was it a form of mockery, a way to heap scorn upon the condemned beast, or was it, in a strange way, a sign of respect for the legal process by dressing the pig as a man? They were visually confirming its status as a legal subject, one that had been tried and condemned under the same laws as a human. It was the final, surreal act in a long play of legal personification. It's a point of contention that highlights how alien their symbolic language can be to our modern minds. The judge bangs his gavel. Court is adjourned. The trial is over. The bailiffs move in, untying the pig from the table leg and beginning the process of hauling it out of the courtroom. The animal squeals. Louder this time, perhaps sensing the rougher handling, the shift in the energy of the room. It has no idea that its legal appeals are exhausted, that its fate is sealed, that in a few hours it will become the centerpiece of another, even more public, ceremony. The community has its verdict. The law has spoken. Now, all that remains is the execution. The guilty verdict has been handed down, and the sentence pronounced. But the grim business of justice is not yet concluded. The execution of a condemned animal wasn't a simple, private affair. It wasn't like a farmer dispatching a sick animal behind the barn. No, this was a public ritual, a formal ceremony designed to be witnessed by the entire community. It was the final act of the legal drama, and it had to be performed with the same gravity and public visibility as the trial itself. You follow the crowd as it spills out of the courthouse and into the main town square. This is the heart of the community, the place where markets are held, proclamations are read, and where human criminals meet their end. A makeshift gallows has been erected, a stark wooden frame against the grey sky. It's the same structure they would use for a person, and its presence lends a terrifying air of legitimacy to the proceedings. The condemned pig is led from the jail, not by a farmer, but by the official executioner. This is a significant detail. The executioner was a state-sanctioned official, a specialist in the grim art of carrying out judicial sentences. His involvement signified that this was not an act of random violence, but the will of the law being carried out. He might be the same man who, last month, hanged a highwayman or branded a thief. Today, his subject has 4 legs. The procession from the jail to the gallows is a solemn one. A priest might even be present. Though his role here is ambiguous, he is not there to offer last rites to the pig, but to sanctify the event, to reaffirm that this act is being done to restore a divinely ordained moral order. The pig, Justin wrote, is probably panicking now, squealing and struggling against its handlers. The noise is jarring, a primal sound of animal fear amidst the somber human ritual. This is where you might witness that strange practice we talked about, the dressing of the condemned. The executioner and his assistants might halt the procession to forcibly dress the pig in some articles of human clothing. They might struggle to pull a pair of breeches onto its hind legs or a waistcoat over its powerful torso. This is not for comedic effect. In their minds, it's a deeply symbolic act. The pig is being visually transformed, forced into the role of the human criminal it has been judged to be. It's the ultimate expression of the trial's logic. If you commit a man's crime, you will die a man's death, in a man's clothes. One of the most vividly documented examples of this, which I mentioned before, is the 1386 execution of the pig of Falaise in Normandy. The town's records meticulously detail the expenses for the event. They include the cost of the new clothes for the pig, the jacket and breeches, as well as the fee for the executioner, and even the cost of the gloves he wore. This level of detail in the accounting reveals how routine and bureaucratic these events were. They even paid for a specially constructed scaffold, built at human height, to properly hang the animal. This leads to a little-known, and rather morbid, piece of trivia about these events: the concept of porcini precedent. The legal system, especially back then, was heavily based on precedent. The way one case was handled would influence future cases. The detailed records of an execution like the one at Falaise, with its specific rituals of mutilation and dressing, would serve as a template. A judge in a neighboring town, faced with a similar case years later, might consult these records and order a similar execution, as was done in the case of the pig of Falaise. This created a sort of grim tradition, ensuring that these bizarre rituals were repeated with legalistic precision across generations. You watch as the executioner finally gets the pig to the base of the gallows. He secures a thick rope, the hangman's noose around its neck. The crowd is silent now. A sea of grim, watchful faces. This is the catharsis they have been waiting for. The trial identified the source of the chaos in their midst. The execution will now purge it. It is a shared, communal experience of purification. With a signal from the magistrate, the executioner does his work. The pig is hauled into the air. Its struggles brief and convulsive. The silence of the crowd is absolute. They are watching the restoration of order in real time. The rip in the fabric of their world, caused by the death of the child, is now being visibly, violently stitched shut. The question of what the audience truly felt is one historians continue to explore. Was it grim satisfaction, religious piety, or was it just the morbid thrill of a public spectacle in an age with little other entertainment? It was likely a complex cocktail of all three. For some, it was a deeply meaningful religious and legal act. For others, it was a day of work and a bit of grisly drama. The motivations were as varied as the people in the crowd. There's no simple answer to what was going through their minds, and this ambiguity makes the scene all the more compelling. After the pig is declared dead, its body might be left to hang for a time, a stark warning to whom, to other pigs, to careless owners, or simply to the community itself. A reminder of the consequences of disorder. Eventually, the body would be cut down. It would not be butchered for meat. An animal executed as a criminal was considered unclean, its flesh tainted by its crime. It would typically be buried in an unconsecrated field or, in some cases, burned. Its legal journey was over, its existence erased. The solemn, bizarre, and terrible process was finally complete. The body of the executed pig has been disposed of, and a strange quiet settles back over the town square. The gallows will be dismantled, and life will return to its normal rhythms. The legal drama is over, but the story isn't, because beneath the surface of all this solemn ritual, theology, and public ceremony, another, more worldly process was at play: the cold, hard reality of money. These trials weren't cheap, and a whole cottage industry of costs, fees, and payments sprang up around them. Let's follow the money. You trail the magistrate back to his office. On his desk is a ledger, and HES not calculating points of law, HES calculating expenses. Every single step of the judicial process you've just witnessed, from the initial investigation to the final execution, generated a bill, and someone had to pay. First, there was the cost of the trial itself. The judge, the clerks, the bailiffs, all these court officials were entitled to a fee for their services. The more complex and drawn out the trial, the more they got paid. This created a subtle, and some historians argue, corrupting incentive. While we can't say for sure that judges deliberately prolonged cases to earn more, the system certainly didn't encourage speedy resolutions. Then you have the jailer, as you learned. The pig was imprisoned at the public's expense. The jailer submitted a bill to the town or the local lord for the animal's room and board. We have actual surviving account books from the 15th century that list these costs. One from the town of Meulan, for instance, records the expense for the food and lodging of the pig while it was in jail. It was a line item, just like paying for the prison guards or buying straw for the human inmates. And let's not forget the defense attorney. If he was court-appointed, his fees were also paid out of the public purse. A good lawyer cost money, and the system, in its commitment to process, dictated that even a pig was entitled to a proper, paid-for defense. The biggest single expense, however, was often the execution. The executioner was a skilled professional, and his services came at a premium. The fee wasn't just for the act of killing, it was for the entire gruesome ceremony. The 13 Itexus accounts from Falaise are a perfect example. They list, with chilling precision, the costs item. For expenses of the sow in jail, 6 sold. Item. To the executioner who came from Paris to perform the said execution, 50 for sold. Item. For the cart that carried the sow to the place of execution, 6 sold. Item. For the ropes to bind and hang it, 2 souls, 8 deniers. Item, for the gloves, 2 deniers. It all adds up. An animal trial could be a significant financial burden on a small community. So who footed the bill for all of this in most cases? It was the local feudal lord or the town council, in other words. The taxpayers. But there was another option. Sometimes, the court would try to recoup the costs from the owner of the condemned animal. Imagine this: not only has your pig been arrested and executed for murder, but now you're getting a bill for the entire affair. You have to pay for the rope that hanged your pig. This practice was, as you can imagine, not particularly popular. This financial angle leads us to a fascinating and slightly cynical bit of historical speculation. Some historians have argued that the choice to prosecute an animal might have occasionally been influenced by the owner's wealth. If the owner was a poor peasant, the lord or town would have to absorb the full cost of the trial. But if the owner was a wealthier farmer, the court knew it had a good chance of getting its money back. This raises the uncomfortable question: was justice for sale, or, more accurately, was the decision to prosecute influenced by the ability to pay? It's a contentious point, and the evidence is circumstantial at best, but it adds a layer of worldly pragmatism to these otherwise surreal events. It reminds us that even in the most faith-driven societies, economics is a way of creeping into every decision. Furthermore, there was the DODM concept we touched on earlier, which was the standard in England but also existed elsewhere. This was the idea that the object or animal causing a death was forfeited to the crown or church. This had a clear financial benefit. The crown could seize a horse that threw its rider or a cart that ran someone over and sell it, with the proceeds supposedly going to charity or to pay for masses for the victim's soul. While distinct from a formal trial, it shows that the legal system had well-established mechanisms for turning tragedy into revenue. The animal trial system, with its fees and billable hours, can be seen as a different, more bureaucratic version of the same principle. Justice has a price tag. You can now see the trial in a new light. It wasn't just a theological drama, it was an economic event. It provided employment for lawyers, jailers, and executioners. It generated paperwork and fees that kept the judicial bureaucracy humming. It was a system that, once started, had a certain financial momentum of its own. Thinking about the sheer cost and the detailed accounting involved makes the whole practice feel even more bizarre. They weren't just committed to the idea of animal justice, they were willing to fund it, document it, and turn it into a full, billable part of their society. The pig wasn't just a murder, it was an economic stimulus package on for legs. Let's leave the grim spectacle of the secular court and its executed pigs behind. Turn your attention away from the town square and towards the rolling fields and vineyards that surround the village. Here, a different kind of crime is taking place. It's not a singular act of violence, but a slow, creeping devastation. A legion of tiny criminals is at work, devouring the community's livelihood. It could be a swarm of locusts darkening the sky, a tide of caterpillars marching through the cabbages, or in the case we'll imagine now, a plague of weevils infesting the grain stores. You can't arrest a weevil. You can't put 1,000,000 locusts in a jail cell. The methods of the secular court arrest, trial, execution are useless here. And so, the villagers turn to the other great power in their lives. The other pyramid of justice, the church. This is where you'll see the legal system take an even more surreal turn. Welcome to the world of the ecclesiastical animal trial. You find yourself in a delegation of anxious-looking farmers and village elders. You're not heading to the local magistrate chateau, you're on a journey to the nearest cathedral city, to the seat of the bishop. Your goal is to file a formal legal complaint, a lawsuit, against an entire species. The process begins in a surprisingly bureaucratic way. A formal petition is drawn up by a cleric or a lawyer, detailing the damages. It would read like a modern civil complaint. The undersigned citizens of the village of be assigned to hereby bring a grievance against the animal known as the weevil, which has, contrary to divine law and natural order, infested our granaries, consuming the grain which is the sustenance of our families and the rightful tithe of Holy Mother Church. The bishop's court, the ecclesiastical court, would then formally accept the case. But as we touched on earlier, their first move wasn't to condemn the insects. It was to turn the spotlight back on the plaintiffs themselves. The church operated on the principle that these kinds of plagues were often a form of divine punishment. So, the first step was a spiritual audit of the community. A priest or commission would be dispatched to the village to investigate. Have you been attending Mass regularly, they would ask. Have you been paying your tithes in full? Is there some unconfessed sin, some heresy or blasphemy festering in your community? The village would be prescribed a course of remedial action. This often involved public prayers, fasting, and a solemn procession around the afflicted fields or granaries. The villagers would march, led by a priest carrying a crucifix or a holy relic, chanting litanies and begging God for forgiveness and deliverance. This was part legal proceeding, part religious therapy. It was a way of making the community feel like they were actively participating in the solution. This leads to a fascinating, unslightly strange bit of trivia: the gentle approach before launching a full-blown legal assault. The church often advocated for a softer, preliminary step. In some regions, the first course of action was to simply try and bless the animals, or, in some cases, to formally bless a separate piece of land and ask them to move there. There is a recorded instance where a priest, faced with a plague of birds, climbed a bell tower and preached a sermon to them, politely asking them to depart and find sustenance elsewhere. It was a mixture of genuine faith in the power of words and a kind of hopeful, ritualized pest control. Only after these preliminary steps failed, after the villagers had repented and the pests had stubbornly refused to leave, would the court escalate to a formal trial. The weevils or locusts, or rats would be declared contumacious, that is, stubbornly disobedient. Then the sole, bizarre force of ecclesiastical law would be brought to bear upon them. The fundamental difference between this court and the secular one you saw before is one of jurisdiction and purpose. The secular court punished a past crime. The church court sought to prevent a future or ongoing one. Its goal wasn't retribution against the weevils for the grain they had already eaten, it was to stop them from eating anymore. They used the law as a tool of magical and spiritual coercion. This dual legal system is a concept that historians refer to as the two swords theory, based on a medieval interpretation of a Bible verse. One sword was the sword of temporal, secular power, held by the king to punish the body. The other was the sword of spiritual power, held by the Pope to guide and, if necessary, punish the soul. The animal trials fell neatly, if bizarrely, into this division. A pig that committed a man-like crime was subject to the king's sword. A swarm of pests, seen as a spiritual or demonic affliction, was subject to the church's sword. The debate over where one sword's authority ended and the other's began was a source of constant tension and conflict between popes and kings for centuries. The animal trials were just one small, strange arena where this epic power struggle played out. So as you stand with the farmers before the gates of the bishop's court, you are entering a different legal universe. The language will be different, less about evidence, more about theology. The procedures will be different, less about incarceration, more about incantation, and the ultimate punishment will be something far stranger, and in their minds, far more terrifying, than a simple hangman's noose. You are about to see how the church wages war on God's tiniest creatures. The church court has agreed to hear the case. The initial investigation into the villagers' piety is complete. The processions have been held. The prayers have been said. And still, the weevils remain, munching away at the town's future. The court has determined that the insects are not a divine punishment but an illegal infestation, an affront to the natural order. It is time to initiate formal legal proceedings against them. The first step, serving them with a court summons. You are now witnessing one of the most purely, wonderfully absurd moments in the history of law. A clerk of the ecclesiastical court, a man in holy orders, is tasked with drafting a legal notice addressed to a species of insect. He sits at a heavy wooden desk, his quill scratching across a sheet of valuable parchment. The document he's creating is not a simple note. It is a formal, legally binding summons, written in ecclesiastical Latin, full of complex legal phrases and theological justifications. The summons would begin with all the formal gravity of a human legal notice. In the name of the Father, the Son, and the Holy Ghost. Amen. Let it be known to the violent cursed creatures known as weevils, currently inhabiting and unlawfully consuming the grain stores of the village of BSY. It would then formally charge them with their crimes: theft of property, damage to the community's livelihood, and disobedience to God's will. The document would then command the weevils, or a representative delegation thereof, to appear before the ecclesiastical court on a specific date and at a specific time to answer for their crimes. It would warn them that failure to appear would result in a judgment being entered against them in absentia. It was, in every sense, a real, official subpoena for bugs. Once the document is drafted, signed, and affixed with the bishop's official seal, it has to be delivered. And how, you might ask, do you serve a subpoena on 1,000,000 tiny weevils? This is where ritual and pragmatism collide in a truly spectacular fashion. The court would dispatch a bailiff, the church's equivalent to the secular court's officer, to the scene of the crime. You follow this man as he carries the precious document back to your village. He doesn't just tack it to a post and call it a day. The delivery is a public ceremony. He gathers the villagers, perhaps the same ones who held the religious procession, and leads them to the afflicted granaries, in a loud, solemn voice that echoes in the dusty air of the storage barns. He reads the entire summons aloud. He reads it directly to the sacks of grain where the weevils are living. He is officially putting them on notice. O weevils, you are hereby summoned. This public reading was crucial. In an age where most of the populace was illiterate, the spoken word carried immense legal and spiritual power. By reading the summons aloud, the bailiff was performing a speech act that, in their minds, made the summons real and binding. The weevils had been told. As a bit of wonderfully strange historical trivia, sometimes this wasn't deemed sufficient to be absolutely sure the message was received. A copy of the written summons would be left at the scene. The bailiff might pin the parchment to a granary door or, in some documented cases involving caterpillars in a field, copies of the summons were affixed to stakes and placed in the four corners of the infested vineyard. The legal notice was posted for the defendants to see, even if they lacked eyes to read it or minds to comprehend it. This whole process raises a question that historians and theologians of the time actually debated, and modern historians still find fascinating. For a summons to be legally valid, the recipient has to be able to understand it. Did the church officials genuinely believe that the weevils could comprehend the Latin phrases being read to them? The answer is complex. Some of the more literal-minded probably did believe that all of God's creatures had some innate, primal understanding of divine law, but the more sophisticated legal and theological minds had a different justification. They argued that the summons wasn't just for the animals. It was also for the ears of the demonic spirits that were believed to be directing or corrupting the animals. In this worldview, a plague of pests wasn't just a natural phenomenon, it was often seen as the work of Satan or his minions, using the tiny creatures as their instruments to torment mankind. Therefore, the legal summons was a challenge thrown down not just to the weevils, but to the infernal powers behind them. The demons certainly understood Latin, and they would know that their little scheme had been discovered and was now being challenged by the full authority of the church. This interpretation transforms the act from a farce into a form of ritual exorcism, a legal battle waged on a supernatural plane. Whether the average peasant in the crowd understood this nuance is debatable, but for the church lawyers who designed the system, it provided a solid theological foundation for their bizarre actions. So as the bailiff finishes his reading and the villagers murmur their amens, the first move in this strange chess game has been made. The weevils have been served. The bull, so to speak, is now in their court. The human plaintiffs have done their part. They have followed the rules. Now, They must wait for the appointed day to see if the defendants choose to appear in court and answer the charges. The day of the trial arrives. We're back in the grand ecclesiastical courtroom in the cathedral city. The atmosphere here is different from the secular court. It's quieter, more cerebral. The air smells of old parchment and beeswax, not damp stone and fear. A panel of learned clerics, presided over by a bishop or his representative, sits in judgment. The plaintiffs, the delegation from your village, are present, their faces etched with anxious hope. The prosecutor for the church is ready with his arguments. Everything is in place for a formal legal proceeding. There's just one problem. The defendants haven't shown up. The courtroom doors remain shut. No delegation of weevils scuttles up the aisle. No representative caterpillar inches its way to the defendant's lectern. The bailiff formally announces to the court that the defendants, despite being lawfully and publicly summoned, have failed to appear. This is, of course, the moment where the entire process threatens to collapse into pure absurdity. But the ecclesiastical court was prepared for this inevitability. The failure of the defendants to appear was not a reason to dismiss the case. It was a crucial part of the process. The trial would now proceed in absentia, or in their absence. But before a default judgment could be entered, the system, in its peculiar insistence on fairness, demanded one more step. The absent pests had to be provided with a legal defense. Just like the pig in the secular court, the weevils were appointed a defense attorney. Imagine being that lawyer. Your clients are not only a species of insect, but they have also refused to even acknowledge the court's authority by showing up. This is where some of the most brilliantly creative lawyering in history occurred. The lawyer appointed to defend the absent pests had a sacred duty to argue on their behalf. And men like the great Bartholomew Chasney took this duty to extraordinary heights. The lawyer for the weevils would now rise to address the court. His first and most obvious line of defense was to justify his client's absence. As we saw with Chasney's defense of the rats, he might argue the perils of the journey. But for creatures as small and numerous as weevils, he might take a different tack. He could argue, with a perfectly straight face, that the summons was procedurally flawed. Your Eminence, he might say, the summons was issued to the weevils to be a sign why. This is a collective term. My clients are individuals. The summons did not name each and every one of them personally. How can they be expected to answer a charge that is not addressed to them in their individual capacity? It's a ludicrous, hair-splitting argument. But it uses the law's own love for precision against itself. He might also argue that his clients are, by their very nature, humble and timid creatures. The prospect of appearing in such an august and intimidating courtroom, before so many learned men, would surely have filled their tiny hearts with terror. Their absence, he could argue, is not a sign of contempt for the court, but of their profound and understandable fear. This is a great place for a little-known, almost unbelievable historical tidbit. In one documented case, a lawyer defending a group of animal pests successfully argued that because his clients were scattered across a wide diocese, a single summons read in one location was insufficient. He argued that for the summons to be legally binding on every single creature, it must be read aloud in every parish church in the region. The court, committed to its own procedural integrity, agreed. This brought the pests and the villagers they were plaguing a significant delay while priests all over the diocese were instructed to read out the strange legal notice from their pulpits. It was a masterful use of bureaucratic delay. After arguing about the absence, the lawyer would move on to defending the pests on the merits of the case. He would likely use the same theological arguments the pig's lawyer used. He would talk about God's creation. Did God not create these creatures, he would ask the clerical judges. Do they not have a place in his divine plan? The Bible tells us that God provides for the sparrow. Does he not also provide for the weevil? Perhaps the grain they consume is simply their rightful share, the portion that God, in his unknowable wisdom, has allotted to them. This argument put the court in a very difficult position. By prosecuting the weevils, Were they implicitly questioning the wisdom of God's creation? It was a bold and dangerous line of reasoning, and it took a skilled theologian lawyer to walk it without straying into heresy. The question that hovers over this entire scene, which scholars still passionately debate, is what was the real point of this defense? No one, not even the most brilliant lawyer, actually expected to win an acquittal for a swarm of locusts. The purpose wasn't to free the clients. The purpose was to demonstrate the unimpeachable fairness and legitimacy of the church's legal process, by providing the pests with a vigorous, learned defense. The church was showing that its justice was so perfect, so complete, that it gave every opportunity for the accused to be heard, even when the accused were bugs. The defense was part of the ritual. It was a necessary step that had to be performed before the church could, in good conscience, move to the final, inevitable step, the verdict and the sentence. The lawyer's speech concludes. The judges nod gravely, acknowledging the skill of his arguments. They may even commend him for his service to the court and to his silent, absent clients. But the outcome is a foregone conclusion. The defense was a performance, and now it is over. The court will now deliberate and render its verdict on the silent, munching defendants. The defense attorney for the Weevils has presented his case with all the procedural flair and theological creativity he could muster. The clerical judges have listened patiently, but the fields are still infested. The granaries are still being emptied. The time for legal arguments is over. The court finds the absent defendants guilty of theft, of property damage, and most importantly, of contumacy, of stubbornly disobeying a direct order from the church. Now comes the sentence. The secular court had a simple, brutal tool, the gallows, but the ecclesiastical court's power was not over the body, but over the soul. Its ultimate weapon was spiritual, but in the medieval mind, it was just as terrifying. The bishop or his representative now stands to deliver the sentence. The punishment for the Weevils is to be anathema, excommunication, and a formal curse. This wasn't just a judge saying, "I'm angry at you." An anathema was one of the most powerful and feared ritual acts in the church's arsenal. It was a formal, liturgical ceremony that severed the recipient from the community of the faithful and the grace of God. It was normally reserved for the most unrepentant heretics, schismatics, or enemies of the church. And now, this tremendous spiritual cannon was being aimed at a swarm of insects. The bishop would read the sentence from a formal document. The language was often terrifying, drawing on the most potent curses from the Bible. In the name of the Almighty God, the Father, the Son, and the Holy Spirit, and by the authority of the blessed apostles Peter and Paul, we do hereby excommunicate and anathematize the wretched and pestiferous creatures known as weevils. The curse would then go into vivid detail. May they be cursed in the fields and in the granaries, cursed in their coming in and their going out, cursed in their heads and their bodies. May the heavens above them be as brass and the earth beneath them as iron. We separate them from the grace of God and the community of the faithful, and we deliver them unto the power of Satan, to be tormented until they shall cease their depredations and depart from this place. As the bishop read these words, the ceremony would often be accompanied by powerful symbolic actions. He might be surrounded by 12 priests holding lit candles. At the climax of the curse, the bishop would give a signal, and all the priests would throw their candles to the ground and snuff them out with their feet. This symbolized the extinguishing of the spiritual light for the accursed. At the same time, a bell might be tolled, not in the joyful peal of a celebration, but in the slow, mournful clang used for a funeral. It was the death knell of the weevil's souls. This leads to a wonderfully specific bit of historical trivia known as the curse of the Spanish fly. The Spanish fly, or blister beetle, was a pest that plagued vineyards, but it was also the source of charidin, a powerful and infamous aphrodisiac. In one ecclesiastical trial against these beetles, the church officials had to be very careful with their curse. They couldn't just curse the entire species out of existence, because it had a medically and recreationally useful purpose, so they crafted a very specific, legally worded curse that commanded the beetles to depart from the vineyards where they were causing damage, but did not condemn the entire species. It was, in essence, a spiritual restraining order, not a death sentence. This shows the incredible, almost comical, legalistic precision they applied to these supernatural proceedings. The anathema was the court's final move. It was the ultimate expression of the church's power over the natural and supernatural worlds. But did they actually believe it would work? Did they expect the weevils to suddenly pack their tiny bags and leave? The answer, as always, is complicated. For the villagers and many of the local clergy, the belief was likely very direct and literal. They had seen the power of the church in all other aspects of their lives. Why wouldn't its most powerful curse work on pests? It was an act of faith. For the highly educated church lawyers and theologians who ran the system, the thinking might have been more nuanced. Historians who study this period often debate the true purpose of the anathema. Was it a primitive form of pest control, a magical act meant to yield a direct result, or was it primarily a tool for social control and psychological relief? By performing this powerful, dramatic ritual, the church was demonstrating its authority and its concern for the welfare of the people. It provided a focal point for the community's anxiety and anger. It gave them a sense of agency in a situation where they were otherwise helpless. The harvest might still fail, but at least they had done something. They had fought back using the most powerful weapons they knew. The anathema wasn't just aimed at the bugs, it was aimed at the despair of the farmers. The ceremony concludes. The candles are extinguished. The final amen has been spoken. The curse has been unleashed. The villagers return home, their legal and spiritual battle now complete. All they can do now is wait and watch, praying that the full, terrifying power of the church's judgment will be enough to save their harvest. They have taken on an army of insects and fought them not with poison, but with prayers, lawyers, and a truly epic curse. We've seen the grim justice of the secular courts for pigs and the sweeping spiritual warfare of the church courts against pests. But sometimes, these two worlds would collide in a single case, creating a legal spectacle of almost unbelievable strangeness. These were cases born not from tangible harm like a dead child or a lost harvest, but from pure, unadulterated superstition. Let's travel to the city of Basel, Switzerland, in the year 1474, for what is arguably the most famous and bizarre animal trial of them all, the trial of the rooster of Basel. You find yourself in a packed courtroom, even more crowded than the one for the pig. The sense of anticipation is electric, but it's mixed with a current of deep fear. The defendant is brought forth, held not in ropes, but in a cage. It is a rooster, looking exactly as a rooster should, proud, colourful, and utterly oblivious to the gravity of its situation. And what was its crime? It had, allegedly, made an egg. To your modern mind, this is a biological impossibility. Roosters don't lay eggs. You might assume the whole thing is a mistake, a prank, or that the accused is actually a hen. But in the 15th century mind, a rooster laying an egg was not a biological absurdity, it was a profoundly unnatural and evil act. It was a sign of witchcraft, a portent of doom. The superstition surrounding the cock's egg was ancient and widespread. It was believed that an egg laid by a rooster was not a normal egg. It was a demonic vessel. If this egg were to be hatched preferably by a toad, it would not produce a chick. It would produce a cockatrice, or a basilisk, one of the most feared monsters in medieval mythology. A basilisk was a reptilian creature, often depicted as a serpent with a crown, whose gaze was instantly fatal. The mere existence of a cock's egg in a town was considered a dire threat, a demonic time bomb waiting to unleash hell on earth. So, when a rooster in Basel was accused of this unnatural act, the authorities reacted with the utmost seriousness. This wasn't a simple case for the church court, because there was a physical object, the egg, and a single, identifiable defendant, the rooster. But it also wasn't a standard case for the secular court, because the crime wasn't murder or theft, it was a crime against nature itself, deeply tied to demonic magic. The result was a full-blown secular trial, but one saturated with the theological fears of witchcraft and heresy. The prosecution presented its case. The star witness was, of course, the egg itself. It was brought into the courtroom on a velvet cushion, a small, probably misshapen, yolkless wind egg, which can occasionally be produced by hens, but to the court, it was Exhibit A in a case of demonic collusion. Witnesses were called who testified that they had seen the rooster acting strangely, that they had found the egg in its nest. The rooster, like the pig before it, was provided with a defense attorney. This poor lawyer was faced with an even more impossible task than his colleagues. The pig's lawyer could argue about instinct. The weasel's lawyer could argue about procedural errors. How do you defend a rooster against a charge that is, by its very definition, supernatural? The lawyer reportedly put forth a valiant, if doomed, defense. He argued that there was no evidence that his client had any pact with the devil. He argued that the laying of the egg was an involuntary act, and that his client should not be held responsible for a biological anomaly that it could not control. He was essentially arguing that it was a freak of nature, not an act of malice. It was a surprisingly modern, scientific defense in a court consumed by superstition. This is where we find a small, but fascinating, historical debate. Some modern commentators have suggested a more cynical interpretation of the trial, as it was, at the time, trying to attract a major church council. Some historians have speculated that the city authorities staged this very public, very pious trial as a way of advertising their religious fervor and moral rectitude. Look at us. They were essentially saying to the wider world, we are so vigilant against the forces of darkness that we even prosecute diabolical chickens. It may have been less about genuine fear of a basilisk and more about political public relations. We can never know for sure. But it adds an intriguing layer of Machiavellian politics to the already bizarre proceedings. The defense attorney's rational arguments were, of course, no match for the deeply ingrained fear and superstition of the court. The judges were not interested in biology, they were interested in rooting out evil. The rooster was swiftly found guilty of the heinous and unnatural crime of laying an egg. And the sentence, the rooster and its demonic egg could not simply be killed. They had to be destroyed in a way that would purge their evil. A method reserved for the most vile heretics, and which is they were to be burned at the stake. You now find yourself in the public square, in a scene that mirrors the witch burnings that would become horrificously common in the coming centuries. A pyre has been built. The executioner brings forth the caged rooster and the infamous egg. With all the solemnity of a religious ceremony, he places the rooster and the egg upon the pyre. A priest might offer a prayer for the purification of the town. Then, a torch is set to the wood. The crowd watches in hushed silence as the flames consume the rooster and its unholy creation. They believe they are witnessing not just an execution, but an exorcism. They are seeing their community being cleansed of a demonic threat. The trial of the rooster of Basel remains one of the most vivid examples of how the medieval legal system could be used to prosecute not just crime, but fear itself. It's a chilling reminder that when superstition holds sway, the sole, terrifying force of the law can be brought to bear on the most impossible of crimes. After the high drama of a rooster being burned at the stake, let's turn to a case that feels less like a horror story and more like a deeply strange, drawn-out civil dispute. We move back to France, to the town of Autun in the 16th century. This is the stage for the legendary legal battle involving the aforementioned master of animal law, Bartholomew Chesney, and his most famous clients, the field rats of Autun. This wasn't a criminal trial in the same vein as the pig or the rooster. It was an ecclesiastical case, but with a twist. The farmers of Autun were suffering from a devastating plague of rats that were destroying their barley crops. They did what villagers did, they petitioned the bishop's court to take action. The court, following standard procedure, issued a summons for the rats to appear and answer for the damage. And, as expected, the rats failed to show up. The prosecutor for the church immediately demanded that the court issue a curse and excommunicate the pests. It seemed like an open and shut case. But then, the court, in its wisdom and its strict adherence to procedure, appointed a defense counsel for the absent rodents. That counsel was the young, ambitious, and brilliantly clever Bartholomew Chasney, and he was not about to let his clients be condemned without a fight. This is where the story transforms from a standard ecclesiastical trial into a masterclass in legal obstruction and creative argumentation. Chasney stood before the clerical court and began a defense so audacious that it would make him a legal legend. His first move, as we've touched upon, was to address his client's failure to appear. He didn't make excuses, he made a formal legal argument. He claimed the summons was invalid. Why? Because it had been issued to the Rats of Autumn as a collective. He argued that his clients lived in many different villages across the entire diocese. A single summons in the city of Autumn was not sufficient notice for all of them. He argued that, for the summons to be valid, it had to be announced from the pulpit of every single parish church in the region, so that every last rat would have a fair chance to hear it. The court, prioritizing its own procedural correctness above all else, conceded the point. The case was delayed for weeks while the bizarre order was carried out. This was Chasney's strategy in a nutshell: used the system's own rules to tie it in knots. He was not just defending the rats, he was stress-testing the very limits of ecclesiastical law. Once the widespread summons had been read and the rats, once again, failed to appear, the prosecutor again demanded a sentence. But Chasney was just getting started. He rose again, this time with the now famous argument about the perils of the journey. He painted a vivid picture for the judges of the dangers his small and feeble clients would face. "Consider, Your Eminences," he likely argued, "the long and arduous journey my clients must undertake. And along this journey, they face the constant threat of their mortal enemies, the cats, who, being agents of a different jurisdiction, lie in wait. My clients have a reasonable fear for their lives, and the law states that a defendant cannot be compelled to appear in court if the journey itself poses a mortal threat." This argument, so brilliant in its logic, placed the court in a bind. They couldn't deny the truth of it. So, in a move that sounds like it's from a comedy sketch, the court issued a formal injunction against the cats of Autumn, warning them not to molest the rats as they made their way to court. The legal absurdity was piling up. This case is a fantastic example of a historical puzzle that scholars still enjoy. Was Chasney for real? Did he genuinely believe he was fighting for the rights of the rats? Or was this the ultimate act of cynical, brilliant careerism? The most common interpretation is that Chasney was using this high-profile, ridiculous case as a public stage to demonstrate his unparalleled mastery of the law. He was showing every potential wealthy client in the region that if he could mount this kind of dazzling, impenetrable defense for a pack of rats, imagine what he could do for a human being with a genuine legal problem. The rat trail was, in essence, the most spectacular advertisement a young lawyer could ever dream of. It was a viral marketing campaign, 16th century style. The final act of the trail is the most sublime. After all the delays, all the arguments and injunctions, the rats, for a third time, failed to appear. The prosecutor, now utterly exasperated, demanded a final, irrevocable sentence. Chasney stood up one last time. He did not offer another excuse. Instead, he launched into a grand, theological argument about the nature of justice and property. He argued that the rats, like all creatures, were part of God's creation. He cited passages from the Bible. He argued that the fields did not belong solely to the farmers of Autumn, but to God, and that God's lesser creatures had a right to sustenance. He essentially put the farmers on trial, suggesting their claim to the barley was a form of selfish greed, a failure to recognize their place in a larger divine ecosystem. He turned the case completely on its head. The rats weren't the criminals, they were simply taking their divinely allotted share. The ultimate outcome of the trial is, frustratingly, lost to history. The surviving records of the case cut off before a final verdict is rendered. We don't know if Chasney's final, brilliant argument succeeded in saving the rats from a formal curse. But in a way, it doesn't matter. The legend of the trial of the rats of Autumn is not about the verdict. It's about the process. It is the ultimate example of how the internal logic of the animal trial system could be stretched, twisted, and manipulated by a legal genius to create a spectacle of pure, sublime, and unforgettable legal absurdity. While pigs, rats, and roosters were the A-list celebrities of the medieval animal court circuit, they were by no means the only creatures to find themselves on the wrong side of the law. The legal net was cast surprisingly wide, entangling a whole menagerie of other animals in both secular and ecclesiastical disputes. Each case, in its own way, reflects the specific anxieties and beliefs of the community that brought it to trial. Let's start with the humble donkey. Donkeys were beasts of burden, essential to medieval agriculture and commerce. But they could also be, well, stubborn and occasionally destructive. In 1750, in the town of Anvers, France, in what is considered one of the very last of these trials, a donkey was put on trial alongside a man. The charge was bestiality. The man was found guilty and sentenced to death. The donkey, however, had a surprising stroke of luck. The prior of the local convent and several prominent citizens of the town submitted a formal deposition to the court on the donkey's behalf. This document, which still survives, is a masterpiece of its kind. It was essentially a character reference for the donkey. The citizens testified that they had known the donkey for many years and that she had always shown herself to be virtuous and well-behaved both at home and abroad, and had never given occasion of scandal to anyone. In light of this stellar character reference, and given that the donkey was a victim in the crime and not a willing participant, the court acquitted her. The donkey was saved by its good reputation. The man, unfortunately, was not so lucky. Horses, too, could find themselves in court as valuable and powerful animals. Their actions had serious consequences. A horse that threw and killed its rider could be condemned under the English Deodean system, where it was forfeited to the crown. But in continental Europe, it could face a formal trial. In one case from 1389, a horse was sentenced to be executed for having killed a man. The sentence was passed with the same gravity as if the horse had been a human murderer, reaffirming the principle that the act of killing a person, no matter the perpetrator, was a capital crime. Even creatures of the sea were not immune. In the late 15th century, the coastal waters near Marseille in France were plagued by an unusually large and aggressive number of dolphins. The dolphins were damaging fishing nets and disrupting the local fishing industry, which was the lifeblood of the community. The fishermen, at their wits' end, did what medieval people did. They went to court. They filed a formal complaint with the local ecclesiastical court. The case proceeded along the now familiar lines of a pest prosecution. A summons was likely issued to the dolphins, ordering them to cease their destructive behavior and depart from the coastal waters. The ultimate outcome isn't clearly recorded, but it likely ended with some form of formal curse or anathema being pronounced over the waves, aimed at the offending marine mammals. This case is a wonderful example of a little-known aspect of these trials, their use in economic disputes. The dolphin trial wasn't about moral outrage or fear of the supernatural. It was a legal mechanism for a community to deal with a threat to its livelihood. By taking the dolphins to court, the fishermen were formalizing their grievance and calling upon the highest power. They knew the church to intervene in an economic crisis. It was a lawsuit over resource competition, where one of the parties just happened to be a pod of dolphins. The historical debate around these more obscure cases is quite interesting. Some historians see them as proof of just how deeply the legalistic worldview penetrated every aspect of medieval life. No creature was too big, too small, or too wet to be subject to the law. Others, however, argue for a more pragmatic interpretation. They suggest that these trials were often a last resort for communities facing problems they couldn't solve through practical means. You can't reason with dolphins or predict when a horse will bolt. In a world without modern science or technology to explain and control these events, the law, with its rituals, its authority, and its connection to divine power, was the most powerful tool they had. The trial was a way of imposing a human, rational seeming order on a chaotic and unpredictable natural world. From the donkey saved by a good character reference to the dolphin sued for damaging fishing nets. These cases show the incredible flexibility and scope of the animal trial system. It could be used to prosecute murder, to combat agricultural pests, to condemn superstition, and to settle economic disputes. It seems there was no problem in medieval life so strange that it couldn't, in some way, be turned into a lawsuit. The entire animal kingdom was, at one time or another, potentially standing in the dock. By now, you're probably asking yourself the same question that has puzzled historians for centuries. Why go through all this trouble? Why hire lawyers, convene courts, and hold public executions for pigs and insects? Was it some form of mass insanity to understand the bizarre practice of animal trials? You have to peer deep into the medieval mindset and grasp their profound, all-consuming craving for order. Imagine living in their world for a moment. Life is precarious. You are at the mercy of forces you cannot control. The harvest might fail due to drought or flood. A new plague could sweep through your village, wiping out half the population. Your child could die from a fever that has no name and no cure. Your world is governed by a constant, terrifying uncertainty. In the face of this chaos, humanity has always sought patterns, explanations, and systems of control. For the people of the Middle Ages, that system was a rigid, divinely ordained universal order. This worldview is often visualized as the great chain of being. It was a hierarchical structure, a ladder that stretched from God at the very top, down through the angels, to kings and popes, to nobles, to commoners, then to animals, then to plants, and finally down to inanimate rocks and minerals. Everything in creation had a specific, God-given place on this ladder. A peasant was below a lord, a lion was above a mouse, a rock was below a rose. This wasn't just a social or biological classification, it was a moral and spiritual one. To know your place and to act according to your station was to live a virtuous, orderly life. To step out of your place was to commit a sin, to introduce chaos into God's perfect system. And this is the key to understanding the animal trials. When a pig killed a child, it was doing something monstrously out of character. It was violating its God-given place in the great chain. A pig belongs below a human. For a pig to kill a human was a violent inversion of the proper order of things. It was a tear in the very fabric of reality. To the medieval mind, this could not go unanswered. It wasn't just a tragedy, it was a crisis of the cosmic order. The trial was the mechanism for mending that tear. Law, in their view, was not a human invention. It was a reflection of divine law. By applying the solemn, ritualized process of the law to the pig, they were not just punishing an animal. They were performing a powerful symbolic act. They were capturing the chaos, subjecting it to the rational seeming process of human judgment which they saw as an extension of God's judgment, and then formally casting it out through a verdict and execution. The trial was a public, communal ritual that reaffirmed the great chain of being. It was a way for the community to look at a horrifying, disorderly event and say, "No, we see this disorder, and we are restoring order. The pig is put back in its place below man, subject to his justice." This craving for order also explains the ecclesiastical trials against pests. A swarm of locusts that devours a crop is nature acting in a chaotic, destructive, and disorderly way. It disrupts the proper functioning of the world. Where fields are meant to grow grain to feed people, the church court's legal process, the summons, the trial. The curse was a way of imposing a human, theological order on this natural chaos. It was a way of speaking to the whirlwind and commanding it to be still, using the language of law and liturgy. A fascinating, and slightly quirky, piece of evidence for this obsession with order comes from the language used in the trial documents themselves. The charges against the animals frequently describe their actions as being against the natural order or a violation of their station. The lawyers and judges were explicitly framing the crimes in the context of this hierarchical worldview. They weren't just prosecuting a pig for killing, they were prosecuting it for insubordination against humanity. Historians have long debated how literally the average person understood these philosophical underpinnings. Did the peasant in the crowd at the pigs hanging think to himself, "Oh, the great chain of being is being restored"? Probably not in those exact terms, but he would have felt it instinctively. He would have felt that something that was wrong had been put right, that a dangerous anomaly had been purged, and that the world was, once again, a little bit safer and more predictable. The scholars and lawyers provided the complex theological and legal framework, but the emotional and psychological need for the ritual was felt by everyone. This ordering function of the trials is what many scholars, like the prominent historian Esther Cohen, believe is the central key to the puzzle. She argued that the trials were a form of social therapy, a way for communities to cope with inexplicable disasters. In a world without scientific explanations, the legal process provided a narrative, a script for dealing with the unthinkable. It gave them a sense of control, however illusory, over a world that was fundamentally uncontrollable. The animal trials were not a sign of a society gone mad. They were a sign of a society desperately, and with all the tools at its disposal, trying to maintain its sanity in a chaotic world. They were the ultimate expression of humanity's deep-seated need to find meaning and order in the face of random tragedy. We firmly established that in this strange legal world, animals could be defendants. They could be charged, tried, unpunished. But the legal system's view of animals was even more complex and contradictory than that. If an animal could be held responsible for its actions as a defendant, did that mean it could also participate in the legal process in other ways? The answer, incredibly, is yes. In certain, specific circumstances, animals could be called upon to act as witnesses. This practice is far rarer and more obscure than the animal trials, but its existence throws the medieval legal mindset into even sharper relief. You have to set aside your modern understanding of a witness, someone who gives verbal testimony under oath. A witness, in this older context, could sometimes be something that simply provided a sign, a form of non-verbal, often supernaturally guided, evidence. The primary way an animal could testify was through a practice. We've already touched upon the ordeal of the bear, or argumentation. This was a form of trial by ordeal, a judicial practice where the guilt or innocence of an accused person was determined by a physical test, the outcome of which was believed to be a direct judgment from God, while it was mostly used on humans. The underlying principle could involve animals. Imagine a murder has been committed, but there are no human witnesses. The victim's body is laid out in the church or the public square. The man suspected of the crime is forced to approach the body and place his hand upon it. The belief was that if the suspect was the true murderer, the victim's wounds would miraculously begin to bleed again, testifying against their killer. God, it was thought, would compel the corpse to bear witness. Now, how does an animal fit into this in cases where a murder was suspected, but the human culprit was unknown? Sometimes a rooster was used as a kind of divine truth detector. This is a practice that lingered in folklore and is mentioned in some older legal texts. The rooster, a creature believed to be sensitive to the spiritual world that crows at the break of day, chasing away the spirits of the night, would be brought near the body, according to the superstition. If the rooster crowed at an unusual time while near the corpse, it was considered a sign from God, a form of testimony pointing towards foul play. The rooster wasn't saying who the killer was, but its crow was a witness to the fact that a murder had indeed occurred. An even more direct, though equally bizarre, form of animal testimony involved the judgment of God using animals in judicial duels. In some parts of early medieval Europe, particularly in Germanic traditions, disputes could be settled by a formal, legally sanctioned duel. The winner was deemed to be in the right, as God would have given him the strength to prevail. This practice was sometimes extended to include animals, especially dogs. There is a famous, semi-legendary account from 14th century France concerning the dog of Montargis. The story goes that a nobleman named Aubry de Montdidier was murdered by another courtier, Richard de Marquegaire. The only witness to the crime was Montdidier's loyal greyhound. The dog showed such persistent and aggressive animosity towards Mac-Air and only Mac-Air that the king and his court became suspicious. Since there was no human testimony, the king, so the story goes, ordered a trial by combat between Mac-Air and the dog. This wasn't just a man fighting a dog, it was a formal judicial duel. An arena was prepared. Mac-Air was armed with a club, the dog was given an empty barrel to use as a refuge. The dog, driven by loyalty to its murdered master, attacked Mac-Air with such ferocity that it managed to pin him to the ground. Fearing for his life, Mac-Air confessed to the murder. The dog's actions were interpreted as a divinely guided testimony, a judgment of God rendered through an animal. This story, while likely embellished over the centuries, highlights a core belief. Historians debate whether the dog of Montargis duel actually happened as described, with many seeing it as a popular folktale that illustrates a legal principle rather than a literal event. However, the fact that the story was so popular and widely believed shows that the concept of an animal acting as an instrument of divine justice was not alien to the medieval mind. It fit within their worldview. God could speak through a burning bush, through a prophet, or if he so chose, through the actions of a loyal dog. This idea of animals as conduits for divine signs complicates our understanding of their legal status. They were not seen as rational, autonomous beings like humans, but they were not seen as mere unthinking objects either. They occupied a strange middle ground. They could be infused with demonic malice, making them criminals, or they could be infused with divine purpose, turning them into witnesses. Their moral and legal status was fluid, dependent on the context and, most importantly, on the human interpretation of their actions. The animal wasn't the one deciding to be a witness, it was the humans, the legal system, that decided to interpret its actions as testimony. The rooster's crow or the dog's attack only became evidence when the court agreed to see it as such. In the end, it all comes back to the human craving for order and meaning. In the absence of clear human evidence, they look to the natural world for signs, for a verdict from a higher authority, and were willing to find it in the most unlikely of witnesses. In the midst of all this solemn absurdity, the lorry pigs and the excommunicated insects, it's easy to imagine medieval Europe as a monolith of bizarre, unquestioning belief. But that's a caricature. History is never that simple. Even in the heart of the age of faith, there were voices of skepticism. There were thoughtful, rational individuals who looked at the practice of putting animals on trial and, to put it mildly, raised an eyebrow. These were the quiet dissenters, the men who dared to suggest that the whole enterprise might be, in fact, ridiculous. Finding these voices is difficult. In an era where heresy could get you into very serious trouble, publicly mocking a legal and religious tradition was not a wise career move. The dissent was often subtle, buried in dense theological texts or the private letters of scholars. But it was there. One of the most prominent early skeptics was a 9th century churchman named Godebald of Lyon. He was a highly respected archbishop, a theologian and a reformer. In his writings, he launched a blistering attack on the popular belief in whether magic and the trials by ordeal. While he didn't directly address animal trials as we've seen them as the practice became more formalized later, he attacked the foundational logic behind them. He argued passionately that God does not intervene so directly unpredictably in the mundane affairs of men. The idea that a priest could control the weather with a prayer, or that the outcome of a duel revealed God's judgment, was, to a Godebald, a pagan superstition that had wrongly crept into Christian thought. He wrote, "The wretched world lies now under the tyranny of folly. Things are believed by Christians of such absurdity as no one ever could aforetime induce the heathen to believe." You can hear the exasperation in his voice. He was, in essence, arguing for a more rational, less magical understanding of faith. By extension, his logic would dismantle the entire basis for the church's trials against pests. If a priest's curse can't stop a hailstorm, why would it stop a swarm of locusts? Godebald was centuries ahead of his time, and his skeptical views were largely ignored, but they show that the intellectual seeds of doubt were planted early. Later, As the trials reached their peak from the 13th to the 17th centuries, the critiques became more direct. One of the most pointed criticisms came from a brilliant, if controversial, 16th century Italian scholar and jurist named Enrico II. He was a founder of a school of thought known as legal humanism, which sought to strip away medieval superstitions and return to the pure logic of classical Roman law. Earlier to directly ridiculed the French practice of trying animals. In one of his works, he recounts the story of the lawyer Bartholomew Chasney and his defense of the rats. But unlike others who saw it as a mark of legal genius, Earlier presented it as a prime example of French legal foolishness. He saw the whole affair not as a solemn proceeding, but as a laughable farce. He used it as a case study to argue that the law should be concerned with rational human beings, not with beasts who act on instinct. This brings us to a wonderfully obscure piece of historical trivia, the lawyer's joke. Oliotio's critique wasn't just a dry academic argument, it was biting satire. He essentially framed the great Chasney as a brilliant lawyer wasting his talents on a ridiculous cause, and the judges who listened to him as credulous fools. His writings were passed around among other humanist scholars, and the story of the French animal courts became something of an inside joke, a symbol of everything that was backward and superstitious about the old way of thinking. Another powerful, though more philosophical, critique came from the great 16th century French essayist, Michel de Montaigne. Montaigne was a master of introspection and skepticism. In his famous essays, he constantly questioned the arrogance of humanity in assuming its superiority over the animal kingdom. While he didn't address the trials directly, his entire philosophical project undermined their foundation. He wrote at length about animal intelligence, emotion, and loyalty, often comparing them favorably to the folly and cruelty of humans. He argued that we have no real way of knowing what goes on in an animal's mind and that it is the height of vanity to judge them by our own standards. How does he know? By the force of his understanding. The secret and internal motions of animals, he asked. By what comparison between them and us does he conclude the stupidity which he attributes to them from Montaigne? The idea of holding a pig morally culpable would have been a prime example of human presumption. These skeptical voices from theologians like Agobard to legal scholars, like Oliot and philosophers like Montaigne were a minority. They did not stop the trials from happening, but their existence is crucial. It shows that the medieval and Renaissance world was not a single, unified mind. It was a place of intellectual ferment and debate. The question of the animal's place in the world as a creature of God, as property, as a legal subject was a genuine, complex problem that people of great intellect grappled with. The official, dominant view led to the spectacle of the courtroom. But, in the quiet of the scholar's study, a different, more modern understanding of the world was slowly taking shape. The dissenters were losing the argument in the 15th century, but they were, ultimately, on the winning side of history. The skeptical voices of men like Oliot and Montaigne were like the first few drops of rain before a storm. They didn't change the weather overnight, but they signaled a profound shift in the intellectual climate of Europe. For centuries, the animal trials had been conducted with a straight face, seen as a sacred duty or unnecessary legal function. But as Europe moved from the late Middle Ages into the Renaissance and the early modern period, you can begin to sense a subtle, but unmistakable, change in attitude. The practice started to seem less sacred and more absurd. This wasn't a sudden event. It was a slow, creeping process of embarrassment. You can see it in the court records themselves. In the earlier trials, from the 13th to the 15th centuries, the documents are uniformly grave. The language is formal. The theological justifications are elaborate, and there is no hint of irony. But as you move into the 17th and 18th centuries, the tone begins to change. The records become sparser, the justifications less grand. You get the feeling that the magistrates and clerks are just going through the motions, following an old tradition that no longer holds the same deep meaning. The public spectacle also began to change. What was once a solemn ceremony of communal purgation slowly devolved into a kind of morbid, carnivalesque entertainment. The focus shifted from religious catharsis to public ridicule. In some of the later recorded cases, you hear of crowds mocking the proceedings, of children jeering at the animal defendant. The deep, terrifying belief that underpinned the trial of the rooster of Basel was being replaced by a kind of detached, slightly cruel amusement. The execution of a pig, which once reaffirmed the cosmic order, was becoming just another strange and bloody show. One of the key drivers of this change was the rise of the printing press and the spread of literacy. The stories of animal trials, particularly the more outlandish ones from France, began to circulate more widely. Thinkers of the Enlightenment, like Voltaire, seized upon these accounts with glee. To them, the animal trials were the perfect symbol of the superstition, ignorance, and religious fanaticism of the Dark Ages they so despised. They used these stories as a rhetorical weapon, a way to mock the old order and promote their own new age of reason. Voltaire, in his philosophical dictionary, writes with dripping sarcasm about the lawyers who defended the cause of the rats. He presents the practice not as a complex historical phenomenon, but as proof of the sheer idiocy of his ancestors. This interpretation, the "aren't our ancestors stupid" school of thought, became incredibly popular, and it has shaped our view of the animal trials ever since. It was powerful propaganda, but it also flattened a complex tradition into a simple punchline. A fascinating, little-known case that illustrates transition perfectly is the 1692 trial of a horse in the fledgling American colony of Massachusetts. A man was accused of bestiality, and both he and the horse were put on trial, following the old biblical law. The man was executed, but the Puritan minister Cotton Mather, a towering intellectual figure of his time, expressed deep unease about the execution of the horse. He wasn't arguing from a modern animal rights perspective. His concern was theological. He worried that by executing the horse, they were giving too much credit to the devil's power to corrupt an innocent beast. He argued for a more enlightened view, suggesting the animal was merely a passive instrument. You can see the old world you're clashing with a new, more rationalist theology. The trial happened, but the intellectual justification for it was beginning to crumble, even in deeply religious Puritan New England. This crumbling was happening all over Europe. The great chain of being, that rigid hierarchy that gave the trials their meaning, was coming under attack from all sides. New scientific discoveries were showing that the natural world operated according to its own impersonal laws, not the moral whims of God. New political philosophies were relocating the source of law from God to human reason and social contracts. In this new intellectual landscape, the idea of a pig having a moral responsibility or an insect's worm being subject to a legal summons began to look not just wrong, but category-crushingly absurd. The debate among historians here is about the pace and nature of this change. Did the intellectual elites, the philosophers and scientists, kill the animal trials with their new ideas, or did the practice simply die out from below? As ordinary people gradually stopped believing in its efficacy and started seeing it as a strange, embarrassing relic of the past, the likely answer is that both things happened at once. The philosophical ground shifted from above, while the foundation of popular belief eroded from below. The trials were left stranded, an ancient stone monument in the middle of a modernizing city, a curiosity that no longer served its original purpose. The shift from sacred to absurd was complete. The curtain was slowly, but surely, falling on one of the strangest legal chapters in human history. The intellectual and cultural ground had been shifting for centuries, but the final, decisive blow against the practice of animal trials didn't come from a lawyer or a priest. It came from a philosopher, a man who, with a single, devastatingly simple idea, redefined the very nature of what it meant to be an animal. That man was the 17th century French philosopher René Descartes. Step into the world of Descartes. It's a world of radical doubt and rational inquiry. He famously decided to doubt everything he couldn't know for certain, until he arrived at his one unshakable truth, I think. Therefore I am. Cogito, ergo sum. This focus on thought, on consciousness and reason, became the bedrock of his entire philosophy, and it had profound, and ultimately fatal, consequences for the legal standing of animals. Descartes looked at the world and divided it into two fundamental substances, mind or soul, res cogitans, which was the stuff of thought, feeling, and consciousness, and matter, res extensa, which was the physical, mechanical stuff that everything else was made of. For Descartes, humans were a unique combination of both. We have physical bodies, but we also possess a rational mind, a soul. Animals, however, were another matter entirely. Descartes argued that animals were pure matter. They were complex, intricate machines, but machines nonetheless. He famously described them as beast machines or automatons. He believed that an animal's cry of pain was not a sign of felt suffering in the way a human experiences it. It was merely a mechanical reaction, like the squeaking of an unoiled wheel or the chime of a clock. A dog might wag its tail, and a cat might purr. But these were just the wiring S and clicking S of a biological machine programmed to behave in certain ways. They had no thoughts, no feelings, no consciousness, and most importantly, no soul. This idea was revolutionary, and it spread like wildfire through the intellectual circles of Europe. It was clean, it was logical, and it fit perfectly into the new mechanical worldview that science was beginning to reveal, and it completely, utterly, and irrevocably destroyed the philosophical foundation of the animal trials. Think about it. The entire premise of an animal trial rested on the idea that the animal defendant possessed some level of agency, some capacity for good or evil, some connection to the moral and divine order. The pig was tried because its act was seen as a malefic an evil deed. The weevils were cursed because they were seen as being aligned with demonic forces. But if an animal is just a machine, a fleshy clockwork, then it can no more commit a crime than a falling rock or a flooding river. A machine cannot have mens rea, a guilty mind. A machine cannot be morally culpable. A machine cannot be evil. It can be dangerous. It can malfunction. It can cause harm. But it cannot be guilty. Punishing a pig for killing a child, in the Cartesian view, would be as nonsensical as putting a hammer on trial for hitting a thumb. The blame, if any, lies with the user of the hammer, or in the case of the pig, its owner. The legal responsibility shifts entirely and permanently back to the human. This philosophical shift provided the final intellectual justification for ending the trials. It gave judges and magistrates a powerful, modern, scientific reason to dismiss these cases as relics of a superstitious past. They no longer had to engage in complex, theological debates about the souls of beasts. They could simply declare that the defendant, being a mere automaton, lacked the legal capacity to be tried. This is where we encounter a rather dark and controversial part of Descartes' legacy. His beast-machine theory was used by some to justify horrific cruelty towards animals. If animals don't truly feel pain, then vivisection, the dissection of living animals for scientific research, was seen as morally unproblematic. There are chilling accounts from the period of scientists cutting open live dogs, who would be yelping and struggling, while the researchers calmly discussed the animal's mechanical reflexes. The same idea that ended the legal prosecution of animals also, in a terrible irony, opened the door to their scientific exploitation. Historians are still debating the full impact of Descartes. Did his philosophy single-handedly kill the animal trials? Or was he simply giving a formal name to a change that was already well underway? It's a classic chicken and egg problem. It is probably most accurate to say that Descartes did not start the fire, but he poured gasoline on it. He provided the knockout intellectual punch that the growing body of skeptics had been waiting for. He articulated a clear, powerful, and modern alternative to the old worldview. And in doing so, he made the idea of trying an animal not just seem old-fashioned, but philosophically impossible. After Descartes, the animal trial was no longer just a strange legal practice. It was a category error. The book was closed, not by a change in the law, but by a fundamental change in the definition of life itself. The the soul had been officially removed from the animal, and with it went any possibility of a fair trial. The philosophical guillotine of Cartesian thought had fallen, and the intellectual case for animal trials was effectively dead. But traditions, especially legal ones, die hard. The practice didn't vanish overnight in a puff of philosophical smoke. It faded away slowly, with a few strange, final gasps in the more remote and traditional corners of Europe. These last recorded animal trials of the 18th and even 19th centuries are fascinating because they feel like ghosts, echoes of a bygone era played out in a world that had already moved on. Let's return to the case we touched on earlier, the 1750 trial of the donkey in Van Vies, France. This is often cited as the last official animal trial in France. What makes it so interesting is how it perfectly encapsulates the transition. On the one hand, you have the persistence of the old for man animal is formally included in a legal proceeding concerning a capital crime. On the other hand, the outcome is strikingly modern. The donkey is acquitted based on testimony about its good character and the recognition that it was a victim, not a perpetrator. The court is still willing to go through the ritual of including the animal, but its legal reasoning is now based on concepts of agency and victimhood that would have been alien to the judges at the pig trial of Falaise 400 years earlier. It's an ancient tradition with a new, more enlightened engine. Even as the formal trials died out in the major legal centers of France and Germany, the underlying belief system lingered. The practice of ecclesiastical curses against pests, which was always a bit more informal, continued for much longer. There are accounts from as late as the 19th century of priests in rural parts of Europe leading processions to infested fields and pronouncing formal curses on insect or rodents. These weren't official court proceedings anymore, but folk rituals, the descendants of the grand ecclesiastical trials of the past. The belief in the power of a sacred curse to combat natural plagues outlived the belief in a pig's legal culpability. One of the last and strangest documented cases that feels like a true animal trial occurred not in Switzerland in 1906. This case is a historical outlier and is often debated, but it's too fascinating to ignore. A group of men were on trial for fraud, but their co-conspirator, and in some ways the star of the show, was a dog. The men had allegedly trained this dog to be a thinking dog, one that could answer questions and perform complex calculations by tapping its paw. They used the dog in a scheme to defraud gullible people. In the trial, the dog was brought into the courtroom, and its role in the scheme was a central part of the proceedings. While the dog itself wasn't formally sentenced, it was treated as a key participant in the crime. The case feels like a bizarre 20th century echo of the medieval practice, a final, faint signal from a world that had otherwise vanished. So why did the practice finally stop for good? We've seen the intellectual reasons, like the philosophy of Descartes, and the cultural shifts of the Enlightenment, but there were also powerful, practical, legal reasons. The 18th and 19th centuries were the great age of legal codification. Rulers like Napoleon sought to sweep away the chaotic mess of old feudal laws, local customs, and overlapping jurisdictions. They replaced it with clear, rational, unified legal codes. The famous Napoleonic Code of 1804, which influenced legal systems across the world, was a key nail in the coffin. This new code was explicitly and exclusively foreign about human citizens. It had no room for the legal personhood of pigs or the jurisdiction of church courts over insects. It defined animals clearly and simply as a form of property. Under the new codes, if a pig killed a child, it was a straightforward issue of the owner's liability. The owner was negligent. The owner must pay damages. The pig itself had no more legal standing than a falling roof tile. The law was finally, and completely, secularized, rationalized, and human-centric. The strange legal space that animals had once occupied was sealed off forever. Historians who look at this final period of decline are often struck by this sense of overlap, of two worlds coexisting uneasily. The donkey of Van Vies being acquitted in 1750 happened only 26 years before the American Declaration of Independence. The last folk curses against insects were happening at the same time the first steam locomotives were chugging across the countryside. The world was modernizing at a breakneck pace, but these ancient beliefs and practices clung on in the shadows. The final animal trial wasn't a grand, dramatic event. It was more like the end of a long, slow exhale. The last curse was muttered over a field. The last strange case file was closed in a dusty rural courthouse. And without any official decree, the practice simply ceased to be. The courts and the world had moved on. The idea of a pig on trial had completed its long journey from a sacred necessity to a solemn farce, to a superstitious relic, and finally, into the quiet oblivion of history. So, the courtroom doors have closed on the last animal defendant. The gallows in the towns where have been dismantled for the final time. The strange, centuries-long tradition has faded into the history books, becoming a quirky footnote we might read about with a sense of detached amusement. But is the story really over, or do the echoes of these bizarre trials still linger in our modern world, in ways we might not expect? When you peel back the layers of our own sophisticated, 21st century legal system, you can find some surprisingly familiar-looking ideas. The core questions that the medieval courts wrestled with: what is the moral and legal status of an animal? Can an animal be held responsible for the harm it causes? What is the relationship between an animal's action and its owner's liability? Are questions we are still struggling with today. We just use different language to ask them. Consider the modern laws concerning dangerous dogs. If a dog of a specific breed attacks someone, the law often treats that animal differently. In some jurisdictions, the dog can be declared vicious and, after a legal process, can be euthanized. This is not a criminal trial in the medieval sense, but look at the parallels. An animal performs a harmful act. A legal process is initiated. The animal's character and past behavior are assessed, and a final judgment is made, which can result in the state's sanctioned death of the animal. We don't call it an execution, and we don't dress the dog in a tiny waistcoat. But the underlying structure, a legal process to deal with a dangerous animal, is a direct descendant of the logic used in the secular animal trials. The debate in environmental law also carries strange echoes of the ecclesiastical courts. When a corporation pollutes a river, killing the fish and destroying the ecosystem, what is that but a modern, industrial version of a plague of pests destroying a harvest? And how do we respond? We use the law. We file lawsuits. We don't sue the pollution itself, but we sue the human agents behind it. The goal, like in the church courts, is often not just to punish a past act, but to stop an ongoing harm and restore the natural order of the environment. The language has changed from theology to ecology, but the desire to use law to control destructive forces that threaten a community's well-being is exactly the same. This is where you find a fascinating and very modern legal debate that brings the story full circle. The animal rights movement. Today, there are highly respected legal scholars and philosophers who argue that certain animals, particularly great apes, dolphins, and elephants, possess a level of consciousness and self-awareness that should grant them a limited form of legal personhood. They aren't arguing that a chimpanzee should be tried for theft, but they are arguing that it should have the legal right not to be imprisoned or experimented upon. In 2013, the Non-Human Rights Project filed the first ever lawsuits on behalf of chimpanzees, seeking a writ of habeas corpus, a legal action that demands a person be brought before a court to determine if their imprisonment is lawful. Their argument was that these chimps were autonomous, intelligent beings being unlawfully detained in labs and zoos. The courts, so far, have rejected these arguments, but the debate is a serious one, and it's precisely the same debate the medieval lawyers were having, just in a new context. Is an animal just property, or can it be a legal entity with certain rights? That goes to Bartholomew Chasney. One feels would be following these cases with great interest. This brings us to one last, poignant bit of historical irony. The medieval world gave animals legal standing out of a belief that they were part of a moral, divinely ordered universe, and this often led to their execution. The modern world, guided by science, largely stripped them of that standing, redefining them as property or unthinking machines. And now, at the cutting edge of law and science, we are once again debating whether to grant them a form of legal standing, this time not to prosecute them, but to protect them. The pendulum of thought has swung from one extreme to the other and is now, perhaps, seeking a new, more complicated equilibrium. The story of the animal trials is more than just a collection of weird historical anecdotes. It's a distorted mirror. It reflects our own enduring anxieties about justice, our relationship with the natural world, and our constant, deeply human struggle to impose order and meaning on a chaotic world. The next time you see a news story about a controversial animal, or a debate about environmental protection, or a philosophical argument about animal consciousness, listen closely. You might just hear the faint, ghostly echo of a judge in a cold stone hall, calling a pig to the stand. And so, our journey through the strange courthouses of the past comes to a close. The echoes of the bailiff's call and the lawyer's plea begin to fade, replaced by the soft hum of the fan in your room. The weight of all that strange, solemn history begins to lift, becoming lighter now, dissolving like mist. You can feel the hard wooden bench of the courtroom melting away, replaced by the familiar comfort of your own bed. The world of talking lawyers and silent, accused animals recedes, becoming a story that has been told, a memory that now belongs to the quiet landscape of your mind. Let the details soften, the stern face of the judge, the glint in the pig's confused eye, the rustle of the lawyer's parchment. Let them all blur at the edges. They are just pictures now, drifting peacefully in the gentle current of your thoughts. There are no more arguments to be heard, no more verdicts to be rendered. The only order of business now is rest. Feel the stillness settle around you, a deep and welcome silence that the clamor of the past cannot touch. You are safe in your own time, in your own quiet space, where the only law is the gentle gravity of sleep, pulling you down into a deep and restorative peace. The story is over. Let the dream begin. The end of the article. Good night.